So a very good morning, very good afternoon to everyone present here. My name is Julien Chess, and I'll be giving the welcome speech for this second webinar on EU-China Comprehensive Agreement on Investment in Context. So today's webinar is co-organized with my colleague and friend, Professor Mathieu Burnet. We'll also give you his welcome remarks in a few minutes. Let me just say that we are very grateful to the Queen Mary School of Law for the support it provides as a host. It's digital hosting, and credit goes to Queen Mary for this. We're also grateful to EUPLANT program, the Asia Pacific FDI Network, and the City University of Hong Kong for support in organizing the event. So the theme of this series of events reflects the growing recognition of the power and importance of China and the EU in international investment rulemaking, and the vital role investment law plays in shaping global economic governance. So in the first webinar we had on March 8th, we focused on the CAI, market access, and dispute settlement framework. We had around 200 people in attendance and really got a very impressive set of presentations and very good discussions, so that Mathieu and I are now working on putting together a special issue in which most of the papers will be presented and published. Today, we turn our attention to the sustainable development provisions and the question of ratification and related issues and challenges. So in very brief, there's a few things I wanted to highlight before we move forward. I think we wanted to have this webinar focused on sustainable developments and the issues of ratification because they're interlinked. But clearly, the CAI, is very important also when it comes to sustainable developments, at least for three reasons. First, this is the first agreement with a sustainable development chapter that has been agreed by China. So for China, that's the first time. We will discuss the fact that under the CAI, China commits to continuous and sustained efforts to ratify a number of important ILO organization conventions. The sustainable development section of the CAI also is very important because it fundamentally emphasizes regulatory cooperation. It also establishes a separate dispute resolution procedure framework, and it allows the involvement of non-governmental international organizations in the monitoring of the section. And the third element, which I also find very important and that might generate a lot of discussion, is the fact that the CAI obligations with respect to sustainable developments are contingent on the parties' existing mechanisms, and the provision on labor and environmental issues are based upon a complementary effort of the parties in terms of approach. But it seems that the CAI is good, at least in that it locks in a number of reform or commitments for the future, subject to further improvement. Now, it's good, but there are many critics. I think you're all aware of that. I cannot list all of them. You know that the critics have attacked the uncertain enforceability provided by the Section 4. Some experts are also concerned that China and Chairman Xi could try to declare victory, or perhaps they have, and could then drag out implementation or anticipate a difficult ratification in the EU. That's also something we have to discuss. In short, there are many experts thinking that there is a risk that the EU is being instrumentalized or even trapped in this process. So that's why we also wanted to have a session on ratification, and we wanted to have it today, right after the session on labor and environment, because we felt the two are very much interrelated. So in order to discuss these many issues and concerns, which are very important for the future of China and the EU, I'm delighted to welcome all the distinguished participants. I really want to thank our experts for accepting the invitation to join us today. I also thank and welcome the lead discussants who have joined us to share their knowledge and will give useful feedback to all the presenters. And of course, I also warmly welcome all the other experts, colleagues, students who are in attendance. So before to close these brief remarks and handing over to Mathieu, I'd also like to remind you, and especially our moderators, to strictly stick to our time schedule and not to let any session overrun. I think we'll be strict on that. So I sincerely hope you will enjoy today's debates, and I thank you for your participation and support. Mathieu.
Many thanks indeed, Julien, and a very good morning, everyone, and a warm welcome to the second event on the Comprehensive Agreement on Investment. A warm welcome to our speakers, our discussants, but also to the audience, which is also made of a number of our students. So a very warm welcome to everyone. It has been really a pleasure working together with Professor Chess and his team at City University of Hong Kong and the Asia Pacific FDI Network to organize this series of two events, which is, I guess we will all agree, very timely. And if I may just add up a few words to what Julien has just mentioned, we indeed thought when we started thinking about those events that it would be very important to organize, a panel focusing on the ratification process specifically. To be very honest with you, at the time when we planned this session, we did not think that the debate would be so timely, if you like, and I would just like to emphasize a few reasons why indeed, this panel on the ratification process and the prospect and challenges for the ratification of the CAI are indeed elements we all have to be concerned with, or indeed which require our attention. First of all, indeed, on the nature of the agreement, a number of experts, following the negotiations, were expecting the CAI to be a mixed agreement from the perspective of EU law. In view of the agreement, which was concluded in principle by the European Commission and the PRC back in December 2020, it became clear that we would not be talking about a mixed agreement because the agreement as it stands now, does not include any ISDS provision, which means de facto indeed that it will only be, the European Parliament voting on the basis of a simple majority rule and the Council working on the basis of a qualified majority, which will at the end of the day have the last word on the comprehensive agreement on investment and not national or subnational parliaments, as it was indeed expected during the negotiations. Which does not mean that from both the EU and Chinese perspective that the prospects and challenges for the ratification of the CAI will not be heavily politicized. And in that regard, even if investments, relations between the EU and China have always been heavily politicized, it is very clear that the tit-for-tat sanctions over the Xinjiang issues, which have been imposed on both sides in recent days, are very much likely to have an important impact on the ratification of the Comprehensive Agreement on Investment. One of the big questions, which I guess our speakers and discussants will have to address today, relates to the extent to which issues can be compartmentalized in the bilateral relationship between the European Union and China, or to put it in different words, whether indeed, investments can be regarded, investments and the CAI can be regarded as independent issues on their own, or whether they are closely tied indeed with other discussions taking place in the context of the EU-China strategic partnership, including issues of human rights and labor rights. In that regard, it was quite important indeed for us for the session on the ratification process of the CAI to be organized on the same day as indeed the session dealing with section 4 of the CAI, dealing with sustainability and labor rights. So bearing in mind indeed the prospects and challenges for the ratification of the CAI, I'm extremely grateful to the Vice Chair of the INTA Committee, Ms. Marie-Pierre Vedren, to have kindly accepted our invitation to take care of the opening remarks this morning. Ms. Vedren is has been a member of the European Parliament since 2019, where she also acts as the Vice Chair of the Committee on International Trade and also member of the Committee on Petitions. And Ms. Vedren is a member of the parliamentary group Renew Europe. So Ms. Vedren will be directly involved in the upcoming process of ratification of the CAI. So we are extremely grateful to have you with us, Ms. Vedren, and it's now my pleasure to give you the floor for the coming 12 minutes.
Thank you, Mr. Chair, and thank you, Mr. Bernay. I would like to thank you, the Queen Mary University and the University of Hong Kong, for giving me the opportunity to present you my point of view on the CAI. First, since your invitation, the context has profoundly changed. Finally, after repeated demand from the European Parliament on Monday, 22 March 2021, the Foreign Affairs Council unanimously adopted sanctions against 4 Chinese leaders and 1 Chinese state entity responsible for human rights violation against Uyghurs in Xinjiang. By imposing this sanction against high-level dignitary of Chinese regime, the EU has finally shown unity, courage, and determination in the defense of its values. And I welcome the use of our global sanction mechanism and its activation against China, the first time since the event in Thailand more 20 years ago. And the European Union has stood firm against its systematical revolt and spoken out against the massive repression of the Uyghur minority. And I'm glad that these sanctions were taken in cooperation with UK, United States, and Canada. It shows our unity when it comes to defend human rights values. And in retaliation, the Chinese authority have taken sanctions against mates and European institutions, including the European Parliament Subcommittee on Human Rights. And since last Friday, some British, American, and Canadian are also targeted by sanctions. And these retaliations are unacceptable. We, as Europeans, are targeting the human rights violation, and China is replying with sanctions on democracy. And the European Union, with its allies and partners, defend universal values to which China has subscribed, but which is flow more and more every day. And China will not silence us. We will continue to distance the exaction against the Uyghur and the forced repression in Hong Kong. And it is now unthinkable that our parliament will even accept and encourage the idea of ratification and agreement while its member and one of its committee are under sanctions. We must put our values first. And the lift of sanction is a necessary condition, but not a sufficient one. I want to raise many other concerns on this agreement, both on the text and on the context. A bit more than a year before the conclusion of the CAI, the Commission rightly described China on its communication as an economic competitor, strategic partner, and systemic rival. It seems that with the CAI, the Commission has forgotten that China is a systematical rival. On the agreement itself, I'm not convinced by its real added values. It is also true that the main goal of this agreement is to facilitate investments and rebalance our extremely asymmetrical trade relationship. And EU companies have a hard time getting access to the Chinese market. which is not the case for Chinese companies in the EU. And the key word is ensuring more reciprocity. Thus, we cannot deny that this agreement aims to secure the Chinese market opening. And European companies should have more predictability in investing in China. And with this agreement, they should benefit from every new opening, which was not the case before. However, we lack concrete measure, figure, a proper impact assessment to understand in detail what it means in concrete terms. Even with the recent publication of the EU and China's offer, it's quite difficult to see what this agreement will change for our company in China. The European Commission has not given us any concrete example yet. We need to know concretely which sector, expect automotive or banks, will benefit from the agreement. Moreover, according to some research, the car will only benefit between 15 and 20 EU multinationals, around half of which are German. This is another reason for me to remain perplexed about the reality of this agreement to benefit our SMEs and the other companies. A very worrying new development in the EU market access offer to China on press agency and media. The EU has offered a national treatment statute to Chinese in the media sector. And some member states have reservation and will remain close to Chinese investment, such as Belgium, Poland, or Romania. Some will maintain their restriction, some as French and Portugal, but others will completely be open. And knowing the Chinese approach to media freedom, not to say it's total absence, it raised many questions. Moreover, in that specific sector, China will remain completely closed to maintain its authoritarian power on media. And we know the Chinese power in interfering and providing fake news in the EU. So the Commission says that it's a classic EU market access offer. However, in that case, the Commission seems to have forgotten that we are not offering access to our media to a partner, but to a rival. And the crucial point, as it's for all the agreement, will be the implementation and the respect of such commitment. Because concluding an agreement is not the end of the process, it's just the starting point. And preparing the right implementation and the strict enforcement must be our focus. With the KAI, it's even more important. If you see what is currently happening with Australia, the raise many concern in terms of enforcement of the agreement and trusting Chinese authorities. If the intentions as such an agreement is perfectly understandable, we will need to make sure that commitment will become reality. Still on the text, a positive achievement introduced by the KAI is the fight against climate change dimension. We recognize that even this agreement is not a free trade agreement, yet the Commission insists on including a TSD chapter, Trade and Sustainable Development chapter. One of two dimensions is interesting, the Chinese commitment to implement the Paris Agreement. So China is the world's largest carbon emitter, but at the same time, the largest investor in renewable energy. And without China, the Paris Agreement objective will not be reached. And it is in Europe's interest to continue to engage China to curb global greenhouse emission. So the Chinese president has also announced that China strives to reach carbon neutrality before 2060. However, at the same time, China is building and exporting the most coal-fired power station in the world. So China is taking strong declaratory position, but now we need concrete measures to fight against climate change. And on the context, it is clear that the KAI is insufficient to stand before a systematical rival. China remains a systematical rival, especially regarding values, and we cannot ignore the context. and on the conclusion on the CAI. I have already mentioned Hong Kong, Uyghur, but also Tibet, Taiwan, the tension in the Chinese Sea. So the EU needs to be a global player on this issue and to be vocal and to promote higher values. So I'm happy to see for once concluding an agreement has not made us silent when it comes to human violation. And China is violating all its basic international commitments regarding human rights. We are still promoting two different systems. And unfortunately, the CAI is too weak to introduce real change in China. It is excellent news that we have used for the first time our EU Magnetic Act. We should do the same support to the democracy in Hong Kong, and we cannot compromise with higher values. And I would say that, of course, we have a lot of discussion on forced labor. On this issue, the CAI is also a weak instrument. China has only pledged to make continued efforts to sign and ratify the ILO conventions, especially the one on forced labor. And declaratory commitments are not be enough. We must be strong on that point. We must use the CAI as a leverage to put harm and to be forced on forced labor and on the Uyghur situation. So the answer is quite simple. The EU must its trade policy and strengthen its toolbox. The other tool will be needed to reply to this growing context. It's time for the EU to implement new measures and to get actual results regarding the trade agreement. The EU foreign investment screening mechanism must become operational. We have also the upcoming carbon border adjustment mechanism. It must be efficient to fight against unfair foreign competition. And new instruments should also be adopted in order to ban the import of goods produced by forced labor and to ensure due diligence obligation on foreign companies. So we have to open a broader debate on trade and sustainable development provision. Indeed, in order to make this agreement and all free trade or invest agreement to become more acceptable, the trade and sustainable development provision must gain in enforceability. So to conclude, the CAI ratification process is suspended as long sanctions against are here. But as I said, the lift of sanction is only a necessary and pro-military condition. Others are to be met in order to make that this agreement acceptable. And so we are expecting a lot. And to summarize, we have a long series of demands before possibility taking about given our consent to the CAI. First, the lift of the sanction. One hand, China must ratify this convention on forced labor, respect, and enforce them. And the other hand, the EU must use all its tools at its disposal to respond to the human rights values violation, such as forced labor, but also Chinese unfair practice. So only in this context, we will evaluate if this agreement is a real step forward in terms of achieving our strategic autonomy and defending our values and our interests.
Many thanks, Ms. Vaudrenne, for this thought-provoking and comprehensive presentation of your view on the prospects, but also the many challenges indeed on the way towards the ratification or indeed the non-ratification of the CAI. I found particularly interesting, your identification of the multiple instruments at the disposal of the European Union in the area of investment, in the area of the EU's foreign investment strategy. There are obviously bilateral instruments such as the CAI, but indeed more and more unilateral instruments, which have become increasingly important in the relationship with the People's Republic of China. I don't see any questions for you on the chat, and I know that you have to leave quite quickly, if I may just abuse of my, oh, I see that Julien has a question. So Julien, for a question, and then I may have a small one for you, and then promise you we will let you go.
Yeah, it's a chance to have you here today, Madame Vedren. So, my question is going to be very simple, and it's about the Chinese retaliations. That may not be the first matter of concern for the Parliament to analyze them, but I think, like many observers, you will agree that they might not be proportionate, or that they may have a meaning. And so my question is, as we see that some independent researchers are being targeted, some members of the Parliament, isn't that a sign, a political sign that that China is sending, that China would be willing to not to proceed with the KAI? Is that the meaning you think on the part of China, and what kind of importance you give to this as a member of the Parliament?
Many thanks, Julien. And if I may then just add my question, and then we will give you the possibility, obviously, to answer those two questions. I mean, one point which I found particularly interesting, Ms. Vedren, in your presentation, is indeed the fact that after the adoption of the Lisbon Treaty, I mean, the European Parliament has gained an increasingly important role in the EU's foreign trade and investment policy. And but in your presentation, it seemed that there are still significant challenges in terms of coherence, horizontal coherence between the different institutions of the European Union, and in particular in the relationship between the European Commission on the one side and the European Parliament on the other. I mean, you may remember that this was one of the main criticisms made at the time of the ratification process of the Comprehensive Trade Agreement with Canada. So critiques coming from the European Parliament saying that the Parliament had not been sufficiently consulted by the Commission during the negotiations process. So my question would be for you, to what extent have you seen a positive evolution in terms of close coordination between the Commission and the Parliament at the negotiation stage, at the state of negotiations of the KAI, in view of the former practice in the context of other agreements, CETA, but EFTA could also probably be mentioned here. Thank you very much.
Thank you. Maybe I start with your question, Matthew, because like you mentioned, I was just elected in this mandate, so I was not present in the European Parliament when the Commission negotiated the CETA. But since the beginning of my mandate, I have a close relation with the European Commission, and we have a lot of meetings with the chief negotiator on China. And of course, like you mentioned, now the civil society is very involved on trade issue, but also on human rights. So the Commission have to work with us because we are elected by citizens, and now the Commission must work also with National Assembly because they are very involved since Lisbon Treaty. So of course, it's very important for the Commission to work with us. But I think that it's not enough just to explain what is the state of play of the negotiation. The European Parliament must be very involved on this negotiation. And not, for example, not on the KAI, but on the other FTA, for example, Mercosur. We have a long mandate, and now maybe it's time to work on the mandate with the European Parliament when it's so long. So maybe we have to change the role of the European Parliament, but we know that it's always difficult because, like you said, we are also politicians and we have a lot of pressure on the civil society. So, for example, on global issue on our FTA, I live in Brittany and I have a lot of pressure from farmers. But on the KAI, I have a lot of pressure on civil society to respect human rights. So it's why it's always very difficult. And I think it's very important to the Commission to work with a member of the European Parliament. And Julian, on your question, I think that in fact, for it's just my opinion, and I think that the Chinese government wants to conclude the real and concrete step for the Chinese government is the conclusion, maybe not the implementation on the CAI, because the conclusion of the CAI is in the context of the US election also. And it was I think it was very important for us to show to US that Chinese authority have the capacity to conclude an agreement with the EU. So now it's time, like I said in my conclusion, it's time for the European Union to build our strategic autonomy. But it's very difficult because we have to find the right balance between with our relationship with US, with Canada, with Australia, and also we need to work with China because we need to engage China on some issue like climate change. So it's very difficult all the time to find the right balance. And your question is also linked to the question of Matthew about the pressure of civil society. So it's why in the European Parliament, we push a lot for an ambitious TSD chapter because it's about coherency. And if we are coherent, it's more easy to defend our policy.
Thank you very much, Ms. Vedren. And indeed, coherence is a very important legal duty of the European Union according to the treaties. And this is something which we sometimes tend to forget. So thank you really very much for your availability and contribution this morning. So we know that you have to go now. But really, thank you so much for your availability. And we very much hope that this is just the start of a conversation. So thank you again very much for being with us this morning. And it's now time, I think, Julien, to move to your first session.
Exactly. So without transition, if I may say, it's a pleasure for me to welcome you all and share this session number 1, which has been titled EU and China Investments, Right of States to Regulate. So we're going to touch upon many issues here. And let's go straight to the point, to the hot point, if I may say. We will talk about human rights, labor rights, and environmental rights. So many important rights. All the speakers' profiles are available on the web. So if you don't mind, I'll keep my introductory remarks as brief as possible. The first speaker will be Dr. Axel Marks. Axel will focus on labor rights, while Dr. Sunjin Kang, our second speaker, will focus on the January 2021 panel of experts ruling in the dispute between Korea and EU on labor standards and on labor rights. So logical follow-up. And the third speaker will be Dominique Dagbanja, who it's late for him, is in Australia, at the University of West Australia. Dominique will review the key rules on environmental rights. Let me just remind everyone again that each speaker will have a maximum of 12 minutes for his presentation. After the 3 presentations, we will invite our lead discussants to kick off the discussion and comment on the presentations. Can comment, ask any questions as they deem appropriate. We are very privileged to have 2 top experts, Professor Markus Krajewski from Erlangen University and Professor Angelos Dimopoulos from Queen Mary. So both will be the discussants in this session 1. So let me turn to the first speaker. So it's my pleasure to introduce our first speaker for today, who is Dr. Axel Marks, who is Deputy Director at Leuven Center for Global Governance Studies. I believe you are all very familiar with Axel's research, which covers human rights, global governance, governance through trade, and EU trade policy. And I think Axel was the best person to ask to comment on the rules that we find in the CAI on labor rights. So Axel, I hand it over to you.
Thank you very much, Julien, and I hope you can all hear me and see my PowerPoint.
Yes, perfect.
Inviting me and for the kind introduction. So as you said, I will focus on the labor rights provisions in the agreement, and I added to the title from a European perspective. But what I mean is that we know quite well what is the European approach towards addressing sustainable development and labor rights in trade and investment agreements. And I want to actually use that a little bit as a benchmark to see what's in the current agreement as a starting point of the conversation. Of course, as you already outlined in your introduction, if you take it from a Chinese perspective, this evaluation might be different because that for them, it's a first step towards integrating sustainability provisions in the agreement. Before I start looking into the agreement, let me take you one step back to a speech the EU President Charles Michel gave at the UN General Assembly in September of last year, which was very much focused on the importance of trade, not only for the benefits of trade, but also to create a fairer and more sustainable society. And also in that speech, and you have the quote here, is that from actually that moment onward, or let's say from for the future, the EU would be focusing far more on stricter implementation of what they call the standards related to sustainability, to labor rights, in order to level the playing field. So this whole notion of integrating sustainability commitments into agreements, and also, as we heard from the previous speaker, really enforcing them, is becoming high on the political agenda. And if we look at the last trade policy review of the European Commission, an open, sustainable and assertive trade policy, they also put very much emphasis on these universal values, making value chains more sustainable, and so on. And they, of course, operationalize that with reference to the core labor standards of the ILO and others. In the trade policy review, they also mention, of course, explicitly the agreement with China, and they underline this notion of building a fair and rule-based economic relationship with China, really very much based on the implementation and enforcement of principles and rights included in the Sustainable Development Chapter and the Sustainable Development section. So to come to the core of the presentation, to the questions you pose is, does the agreement live up to these aspirations when considering the labor rights commitments from a European perspective? Now, we have a lot of emphasis from the EU. We also heard it from the previous speaker on the importance of these aspects and the way they need to be enforced. So I briefly want to touch upon three broad questions. Are there labor provisions in the agreement? And you might gather the answer is quite easily yes, and I will come back to them. But then the question is, do they break new ground? And maybe more importantly, from a European perspective, do they constitute maybe a step back from the current approach, rather than a step forward as announced by European leaders on the importance of leveling the playing field? And how can we assess that? Of course, we can look at other agreements and the labor provisions therein. And I think that the next speaker will also already do a bit of comparison with the Korea agreement on other aspects. But the previous agreements are a good starting point. But what I also think is a very good starting point is the 15 action point plan the European Commission made a couple of years with regard to strengthening the trade and sustainable development chapters they are including in trade and investment agreements. And actually this 15-point action plan came after a lot of criticism and debates on whether the trade and sustainable development chapters were really delivering. And in order to have a discussion on that, they launched what they call the non-paper, solicited input from academics, civil society, other actors on how to strengthen the trade and sustainable development chapters in agreements. And that resulted in an action plan, which will actually be under review, if we can follow the trade policy review, which was published last month, early this year. So they will actually have an assessment on whether the current and new trade and sustainable development chapters are really strengthened when it comes to enforcing the provisions therein. And I'm not going to, of course, check on all the boxes with the 15 action plan. You see here all the actions which were outlined. But I want to focus on two which I think are important when we look at the China agreement. One is on the role of civil society, and it was already mentioned before. And the second one is under the broad heading of delivering. And that, of course, has to do with really enforcing the provisions in the Trade and Sustainable Development chapter. And with regard to delivering, the action plan made quite a few, let's say, bold moves by really looking and focusing on what we call early ratification or pre-ratification conditionality, in the sense that some core standards and conventions should really be ratified before an agreement can get into place. That was one of the action points, 8. And also it actually broadened the labor rights commitments in trade agreements, not only to the 8 core conventions of the ILO, but was also considering of including new conventions and agreements which have to do with occupational health and safety, labor inspection, and so on. So these, I think, are two very important points to focus on when we talk about, when we look at the agreement, and to see whether it's breaking new ground or even whether it's, let's say, trying to make some adjustments to the previous approach. Now, very briefly, what's in the agreement before we focus on the involvement of stakeholders and on the delivering of the commitments in the agreement. As most of you might have looked at it, it has 4 sections. One deals with the general context and objectives, one with the environment, the 3rd section on labor, and then the 4th section, mechanisms to address differences. And I put in between brackets percentages, which basically roughly corresponds to how much time and place is spent in the subsection on each of these issues. And actually most of the subsection focuses on mechanisms to address differences, where I think it's quite an elaborate description of how these differences might be addressed. And approximately 20% focuses on investment and labor, and has 5 articles, which looks at the right to regulate. And that, of course, means to the right of each of the jurisdictions to have their own levels of domestic labor protection, but also provisions on that these cannot be lowered in order to attract investment, so to level the playing field. There's a dialogue and cooperation on investment-related issues. An article currently without title, but which basically refers to the obligations under the ILO and investment favoring decent work. So that's quite standard. And compared to other trade and sustainable development chapters, although the language is sometimes a bit more, should I say, nuanced. And when you read the different articles in the chapter, you need to appreciate sometimes the subtle language which is in there, which probably results from negotiations which went on. But now quickly on to 2 elements, delivering and the stakeholders. When we talk about delivering, important to focus on is the substance, which conventions are included, and then the process, whether these conventions are already ratified or not by the partners. And when we talk about the process, the important thing is what I mentioned before, whether there's a clear, let's say, early ratification process ongoing to commit to these conventions, which actually are being done prior or during the negotiations. Now, when we look at the conventions which are core and then look at how China is, let's say, relating to them, then if we look at the 8 core conventions, which are typically in the Trade and Sustainable Development chapter, 4 of them, I have put them in bold, are not yet ratified by China. And these are contentious rights related to freedom of association, right to collective bargaining, forced labor, as we heard before, and so on. 4 others are ratified by China. And then when it comes to the expansion of the number of conventions, with regard to labor inspection and others, we also see that quite a few of them are not ratified by China. So let's say the starting point, that's where we stand for the moment, and which actually is a starting point. Then if we look at the language in the text, and the previous speaker already referred to it, that is rather, let's say, open-ended. They will work towards the ratification on its own initiative and so on. So it's not a really very strong commitment there, and I'm also not sure if that can be triggered by the EU. On stakeholders, very briefly, a lot of debate in the literature on the involvement of civil society mechanisms, strengthening domestic advisory groups, really involving stakeholders throughout the process of the trade agreement in relation to monitoring and so on. Also in the 15-point action plan, a lot of attention to it. Literature in the academic literature, people wrote about it on how to strengthen it. If you then read in the agreement with China, the references to stakeholder involvement are actually limited. There's no mentioning of establishing domestic advisory groups or any of the other traditional institutional mechanisms which we see in these agreements. And there are some references in Article 3 which point to non-state stakeholders, but it's always in accordance with domestic law, which is contextualizing already quite a bit on what can be expected from this involvement. In the part on, let's say, settling differences between the parties, there are also some elements on the stakeholders, but they immediately, let's say, are devoid of any implication in the sense that the stakeholders might submit letters and information to the panel of experts which have to discuss these differences, but there is no obligation whatsoever to take this input into account when the panel of experts is making a report. So the involvement of stakeholders from that perspective is actually upfront quite limited. So in conclusion, since my 12 minutes is up, are there liberal provisions in the agreement? Yes. Do they break new ground? No. Do they constitute a step back from the current EU approach? Possibly, and I think if you compare it to other agreements, the current provisions are actually quite weak. Of course, if you do the flip side and you take into account that for China, it's the first time that they include such chapters in these types of agreements. If you look at it from a Chinese perspective, the answers to these questions might actually be quite different. Thank you very much. And I hope I stayed within my time limit.
Thank you very much, Axel. It was perfect. Lots of things that we will discuss. In due course, I'll be happy to come back on these conventions, the ILO conventions that China has not yet ratified, because to know whether we can really expect any change on that soon. So thank you for giving us a very insightful presentation. Let me also say for those who are in attendance that they can use the chat box at any time to ask questions to our speakers. That will facilitate our work as moderators if we can collect the questions during the presentations and put them to the speakers in the Q&A at the end. So don't wait the Q&A to ask questions. I'm delighted to introduce now our second speaker, Dr. Sungjin Kang, who is a practicing lawyer in Korea. Sungjin is currently an advisor at Kim and Cheng. He has also a great experience in Europe because he has been used to practice international trade law and EU competition law in different law firms in Brussels early on. So Sungjin will talk about this very recent ruling rendered under the EU-Korea FTA. We asked Sungjin to look into that given the many similarities between the EU-Korea FTA on labor and the KAI. So Sungjin, the floor is yours.
Thank you very much. My name is Sungjin Kang. I'm currently a lawyer at Kim & Cheng, and As usual, you can see the usual disclaimer that the presentation doesn't reflect the views of my firm, and it's strictly belongs to all errors strictly attributed to the other. So today we're going to start with the background of the dispute and a brief summary of the expert panel report and how it was implemented in Korea and how it can have some impact to the CAI. First of all, Article 13.4 of the Korea EFTA has a provision that the parties should ratify, should work towards the ratify of the ILO fundamental conventions, and also recognize the value of international cooperation, and also affirm the commitment to make Korean labor law to meet the standard up to the European level, which is pretty similar to the respective provisions of the China CAI. And the FTA provisionally entered into force on 1st July 2011. And since the entry into force of the agreement, Korea actually took measures to implement the obligations under Article 13.4 of the agreement. However, because of the domestic political issues, Korea could not ratify the ILO conventions and amend its laws until 2018. Therefore, on the 17th of December 2018, the EU requested for consultation under the Chapter 13 of the Korea-EU FTA. And then, of course, the bilateral consultation failed to result in the agreeable solutions. Therefore, EU requested to establish a panel of experts, which was made up of 3 panelists. But because of the death of the chairman of the panel of experts, the procedure has been delayed quite a while, and then the oral hearing took place only in October 2020. And then on January 2021, the report of the panel of experts was issued. So there were 2 broad issues at stake. First one was definition, some provisions of the Korea Trade Union Labor Relations Adjustment Act. So under the Korean labor law, worker actually meant those who work at a company but for salaries. So it basically excluded self-employed and dismissed and unemployed workers from the definition of the worker. Therefore, the panel found that the definition of worker under Article 2.1 of the TULRAA was not consistent with the principles concerning the fundamental right of freedom of association. And then from that on, limitation of the membership of trade union was also limited to the workers, and therefore the panel of experts found that the limitation of the membership of the trade union to workers was also not consistent with the Korea's obligations under Article 13.43 of the EU-Korea FTA. And then limitation of eligibility to be officers of the trade union, which effectively limited the eligibility to be an officer of the trade union to workers under the same act, was also found inconsistent with the principles concerning the freedom of association under Article 13.43 of the EU-Korea FTA. However, the EU also argued that because of the registration of trade unions was subject to the certification by the local government, it was also inconsistent with the freedom of association under the EU-Korea FTA. However, the panel was unable to conclude that the application of the disqualification grounds set out in the same act would involve unpermitted exercise of discretion on the part of the competent authorities, which means that the authorities actually had was not certain to have discretionary discretion to allow licensing of the trade unions. What actually worked was that when the local government, when the local authorities received the application for registration of trade unions, it was almost automatic to issue the certificate. So therefore, the panel found that the EU failed to establish that the relevant provision was contrary to the Korea's obligation under Article 13.43 of the EU-Korea FTA. And then, of course, the EU argued that the Korea's efforts towards ratifying the fundamental ILO conventions were inadequate under the EU-Korea FTA. However, Korea argued that the language will under the same provision of the FTA was more akin to a declaration of intent than an obligation. However, the panel found that the term will in the FTA actually established a binding legal obligation. Of course, it didn't say that it was kind of the same as the shall, but it somehow imposed binding legal obligation under Article 31 of the Vienna Convention on the Law of Treaties. However, the panel found that the term will make continued and sustained efforts towards ratifying merely states that the parties should make continued and sustained efforts, which does not mean the parties should make continuous and uninterrupted efforts. Therefore, the panel found that the Korea actually tried its best to ratify the fundamental ILO conventions, and therefore rejected the EU's argument that the Korea actually failed to implement Article 13.43 of the EU-Korea FTA. So what was the impact on Korea? Basically, there was no impact to the Korea's labor law reform because the amendment of the laws as well as the ratification process of the ILO conventions was already there for the last 7 years. So basically, Korea worked hard to implement the laws at issues and ratify the conventions at issue. And right before the issuance of the publication of the panel of expert report, Korea amended the labor law provisions at issue. And then Korean National Assembly also ratified the 3 ILO conventions, which was Convention 87, 98, 29, because Korea already ratified the other 4 ILO conventions. But Korea has not ratified Convention 105, which provided for abolition of forced labor convention because of the Korea's penal code. Korean penal code imposes imprisonment for political expression and participation in strikes. And Article 67 of the Korean Penal Code provides that the imprisonment shall be executed by the confinement in prison as well as performance of prescribed work for certain remuneration. As a result, Korean government chose not to ratify this Convention number 105 until it changed the relevant provisions. And what can be the implication to the CAI? The CAI also provides for similar provisions under Section 4, and it also has dispute settlement, which is made up of consultation and panel of experts. As we saw in Korean case, the panel of experts report is not legally binding, and there is also a practical and very serious issue of Convention 105. China also ratified 4 out of 8 fundamental conventions, but considering the current situation between China and other Western countries on Xinjiang issues, can China ratify the C105 and Convention 105 anytime soon? And if China denies the allegations by the EU, what can the EU do under under CAI? And that concludes my presentation. Thank you.
Thank you, Sungjin. So it's a great one. I think you raised very good questions towards the end of your presentation. We will have to come back on these in the Q&A. And I already see some questions coming in the chat box. But now let's turn to the third and the last speaker for this session. So it's my pleasure to welcome Dr. Dominique Dagbanja. Dominique is based in Australia, and he will speak about environments and how the CAI contributes to the regulation, the better regulation of environment between the EU and China. Dominique, you are muted. Still muted.
Good.
Now good.
Yes.
Lovely.
I think sometimes the mouse of the computer misbehaves. Yes, thank you, Julian, for the introduction. First of all, let me say thanks to you and Matthew for the invitation to make this presentation. I'm privileged and honored to have this opportunity to do so. I'm sure there are many scholars in the Asian region who could be invited to make this presentation. I appreciate your interest in my work and for the opportunity to make this presentation. Thank you. So I will be looking at the nexus of investment and environment in the EU-China Comprehensive Agreement on Investment. And particularly, I will be assessing the legal efficacy of the provisions in the agreement. And I have 2 points to make, given the short time that we have to present, which should be my take home for the listeners. My first point is that investment treaty provisions on environmental goods and services, and those that impose positive, negative, enforceable obligations on foreign investors on environmental protection will seem to be the most practical and effective way to achieve environmental protection and sustainable development goals. And just as foreign investors and traders have enforceable rights against host states, environmental harm and environmental damage, as well as violations of human environmental rights that are characteristic of the nature of investment activity, the nature of business activity, must also come with for such foreign investors. Now, my second point that I want to make is about the weak association, the lack of operative effect of the sustainable development provision, particularly those on the environment. Arguments can be made about the enforceability of the environmental provisions in CAI. However, the language in the investment and sustainable development chapter is one of soft law and does not seem to have operative effect. And so the extent to which they are enforceable is less clear or is very much in doubt. So these are the 2 core points that I would like to make in this presentation. Let's begin to look at the environmental protection as an objective in CAI. Now, if we look at the preamble to the agreement, we see that the primary focus of the agreement is on the promotion of investment. So the primary objective is one of an economic one, but the parties have also recognized, and they use the word recognize, their right to adopt and enforce measures to achieve legitimate public policy objectives. And legitimate public policy objectives will include environmental protection. The parties are also determined to promote investment in a manner that supports high level of environmental rights protection, including fighting against climate change. These are all taken from the preamble to the agreement. So a suggestion can be made from the preamble that the parties are not seeking to promote investment in isolation from other broader national interest considerations, and that they are also interested in other national interest considerations such as environmental protection and sustainable development generally. So the point can be made from the preamble that as treaties are supposed to be interpreted in context and to advance their purposes, then the resolution of investment disputes under the agreement ought to take into consideration other objectives, such as environmental protection objective as reflected in the preamble. So I'll shift to look at the scope of the coverage of the investment and environmental provision section. And there is specific, number one, there is specific provision on the right to regulate. There's provision on dialogue and cooperation on investment and environmental related issues. There's provision on multilateral environmental agreements. There's a provision on investment and green growth. And there's a provision on investment and climate change. So this constitutes the scope of the agreement. I will not be able to speak to each of them. I will proceed to look at the right to regulate provision in the agreement. So if we look at Article 1 under the subsection dealing with environment and investment, it provides that the parties recognize the right of each party to determine its sustainable development policies and priorities, to establish its own levels of environmental protection, and to adopt or modify its relevant laws and policies accordingly, consistently with its multilateral commitments in the field of the environment. Now, this provision, Article 1 of the subsection on investment and environment, does not create the right to regulate in itself. It merely recognizes that right. But I say that it allows, nevertheless, the parties to be able to bring in and rely on international environmental law from which the right to regulate is sourced or derived. And that to me means that even if the right to regulate for environmental protection purposes is not positively stated in or sourced from the CHI itself, the laws from which that right to regulate is sourced can be relied on to make a case for the regulation of foreign investors. And then the provision on the right to regulate also deals with the level of environmental protection in Article 2. And it provides that the parties shall ensure that, or each party shall ensure that its laws and policies provide for and encourage high level of environmental protection and improve laws and policies over time. There's also provision to the effect that the parties recognize that it is inappropriate to encourage investment by weakening or reducing the level of protection afforded in domestic environmental law. And then there is provision that no waiver or derogation from environmental laws so as to encourage the establishment, acquisition, or extension of retention of an investment. As well, there is provision that no inaction or failure to effectively enforce environmental laws simply to encourage investment. Now, how do we assess the legal efficacy of these provisions? The language, as I read and you hear from me, you will see, sounds like CHI, where, a multilateral environmental agreements. There are two limitations that are identified in relation to the provisions on the right to regulate. Number one, CAI is not a multilateral environmental agreement with enforceable mechanisms for violations of environmental obligations. Therefore, it is extremely unlikely that a state party would take steps to question another state party which has decided to waive or to derogate, or which has failed to enforce an environmental obligation in order to attract an investor. So that is one limitation that I find with the provision on the right to regulate. Number two, if you look at Article 2.6 of the subsection dealing on investment and environment, it says that a party shall not apply its environmental regulations in a manner that constitutes a disguised restriction on investment or unjust discrimination between investors and investment. But from investment treaty case law, we know that the determination of what constitutes a disguised restriction or unjustified discrimination is not self-judging. It ultimately resides in the bosom and the wisdom of arbitral tribunals. So this limitation in Article 2.6 may very well serve as a restriction on the provisions that seek to preserve the right of states to regulate for environmental protection purposes. There is also a very important provision that I should refer to in the agreement, which is Article 5, dealing with what are shortened as green investment. And it provides that the parties are to facilitate and encourage investment in environmental goods and services. I have been reviewing investment treaties for some time now, and this is not, it's not common to come across provisions of this nature. So this is, in my assessment, a novel provision in this agreement, which is not seen in most investment treaties. And so there is a textual void in investment treaties when it comes to language around environmental goods and services. And so this provision might serve as a reference point for other states that are seeking to provide for effective ways of providing for the protection of the environment. But I think that positive and enforceable obligations could be imposed on foreign investors when their investment and activities are environmental goods and services are related. So that's a novel provision on environmental protection that I have come across. The second component of Article 5 also deals with still on green investment, also provides that the parties are to cooperate, and I quote, by exchanging experiences and good practices related to environmental impact assessment in respect of investment, which are likely to have significant impact on the environment. Now, in my assessment, this is also a novel provision, environmental protection provision in an investment treaty. And it provides opportunities for the parties, the home state, the host state, to be able to work together on how to address environmental issues that are inherent in the nature of the investment involved. But in my view, to make the provision efficacious, there is the need for these exchanges to be engaged prior to the admission and establishment of the investment, so that those obligations that can be factored into the investment contract that the investment will ultimately be signing with the host state. So that is an important provision in the agreement. But the question is, how ambitious is CAI on investment and environment? These are the core sections that I wanted to look at. The provision on the right to regulate, the provision on green investment. I think these are the core ones that seek to address environmental concerns in the agreement. So the question is, how ambitious is CAI on investment and the environment? As I said earlier, we don't have provisions in investment treaty that specifically addresses the subject of environmental goods. So the investment chapter, investment and sustainable development chapter, comes with provisions on investment favoring green growth. But the question is, how do the states ensure that investment favor green growth? So the challenge is one of implementation. So my view is that it is an ambitious goal that, if it is pursued, will help directly connect investment activities and the environment. But there is a challenge as to how this provision is effectively implemented, since not every investment would necessarily be, environmental goods and services related. Just draw my attention in case I'm getting out of time. I'm not monitoring myself. And then there's provision on dialoguing and cooperating on investment-related environmental issues and the mechanisms to address differences over investment and sustainable development issues when they come up. Cooperation is good, but when and how do states operationalize this particular provision? I think that the chapter is very much silent on that. What is new in this agreement, in CAI, when it comes to the environment, the protection of environmental rights, and so forth? Now, when I review the subsection, I see that it seeks to connect the obligations of the parties to protect the environment to their multilateral environmental treaties, which is not something common to find in investment treaties. Connecting environmental law obligations to investment treaty obligations is not common to find in investment treaties. And again, the provision on dialoguing and cooperating on investment-related environmental issues, I haven't really, this is the first time I'm reading this in an investment treaty. So that's a novel provision as well, as I stated earlier. The exchange of experiences and good practices when an investment is going to have a significant impact on the environment. I think that if this is utilized prior to the establishment of the investment, so that the environmental issues are factored into the process of commencing the investment and operating it, I think that will go a long way to improve, the connection between investment and the environment. Mechanisms for resolving differences between the states over investment and sustainable development issues. Essentially, again, this seems to be new to this agreement. There may be a few others that I haven't come across in my research, but this is also seen to be a novel provision in the agreement. And then there are environmental conditions may be imposed as a condition for the licensing of enterprises. And you will find this in Article 2 trade of Section 3 of the agreement. So again, this is a provision that states could utilize to ensure that before an investment is admitted, the relevant environmental considerations will be complied with by the foreign investor. So let me look at the efficacy, draw a conclusion on the efficacy of the provisions dealing with the environment in this agreement. Now, the recognition and reference to multilateral investment treaties. In my research, what I seek to do is to argue that the obligations of states and the national constitutions and international environmental law should determine the obligations of states in terms of the terms that they agree to in investment treaties. So I think it is gratifying to see that this agreement is seeking to connect the environmental obligations of states under general international law and international investment agreements. But there's a lack of positive, negative, enforceable obligations on investors in these agreements. And as I made earlier, the point I made earlier as part of my core points, if we don't impose positive, negative, enforceable obligations on states, it is less likely that we will achieve the goal of environmental protection in international investment law. The investment and sustainable development issues are presented, as issues, as problems for the states. And the agreement, the section is very largely silent on foreign investors. So it would seem to be a problem for states. And yet it is the activities of the foreign investors themselves that are the source of the environmental problem. So that's one issue as well to look at. It is also less clear in what circumstances a party may invoke the provisions on investment and sustainable development issues. Although there's a mechanism for resolving these differences, in what circumstances may those provisions be activated? And finally, the investment and sustainable development chapter seems to stand in isolation from substantive standards of investment protection. For example, do they limit the scope of the performance requirements? Do they limit the scope of national treatment? Do they limit the scope of the most favored nation treatment in Section 2, for example? I haven't come across a general or specific exception for environmental regulation, apart from the provisions that I'm analyzing now. And there are reservations in the schedules, and there will be the need to analyze the extent to which they accommodate environmental regulation. I think I will end the presentation here and then look forward to any questions that may come up. Thank you.
Yeah, fantastic. Thank you, Dominique, for giving us a very insightful presentation. Forgot to mention, and I apologize for the oversight, that your research had won the 2020 award of the UNCTAD and Society of International Economic Law. So that's something very important and quite an achievement. It's a pity we have been able to meet in person since, but the pandemic and other issues made it very difficult. But glad to see you and to have you today. So it's now time to hear our discussants. There'll be only one discussant because Professor Dimopoulos is having technical difficulties joining us. So no problem, because we have the chance to have Professor Markus Krajewski, who can speak for two, who can comment for two. I'm sure Markus will have many things to say. I'm sure you all know Markus, who holds the chair in public law and public international law at the University of Erlangen, Nuremberg. And Markus is an expert who frequently acts as in legal matters, advises organizations, the EU Parliament also, I think, and trade unions. So we thought it was very important to have Markus here to launch the discussion on these three topics, but very deeply interrelated. Markus, you were supposed to have 5 minutes, but you can have up to 5 minutes if you want. Don't feel obliged. I leave it to you. And then we are sure to have a good general Q&A session.
Can you hear me?
Not so good, not so well.
Not so well. Okay.
Oh, now it's good. Now it's good, Markus.
Okay, good. Thank you. Well, thank you for inviting me and having me. And I was actually going to start to say that I'm not going to comment on Dominique's paper because Angelos is the real expert in investment law. But now you sort of put me in a bit of a challenging position, and I'll come up hopefully also with a comment for Dominique. But let me start with first of all, thanking and congratulating you, your universities, and the participating partners for this excellent discussion, very timely discussion, also for involving political stakeholders. I want to make 3 comments. The first will be on the presentation by Axel, and specifically on this regulatory technique that we see in Article 4 of the part on trade and labor, and Axel spoke about this quite extensively. So I just wanted to draw the attention of everyone to the fact that we do actually indeed have in that article a distinction, if you wish, a hierarchy of different ILO labor conventions. So we have, of course, the general obligation, which is in Article 4, paragraph 2, where it says that all the parties should commit to effectively implement and ratify those conventions they haven't ratified yet. And then in particular, it has obviously the core labor conventions 29 and 105, which are on forced labor. And I mean, for obvious reasons that can be explained, there is this distinction, but I just want to challenge that distinction from 3 different perspectives. The first is actually the perspective of the ILO itself. mean, the ILO came up in the Declaration of Fundamental Principles and the Rights at Work, came up with the idea that there should be 8 core labor principles and therefore 8 core labor conventions. So it seems to me already from the perspective of ILO law, it would be questionable and can be criticized to distinguish, to basically build in this hierarchy where you have 2 conventions which you have a priority on. Secondly, I would also argue that you can challenge it from the perspective of human rights law, because of course, these core ILO conventions concretize human rights at work. And one can argue that the forced labor conventions concretize Article 6 of the International Covenant on Economic, Social, Cultural Rights, and the collective labor agreements 87 and 98 obviously concretize Article 8 and of the Covenant on Economic, Social, Cultural Rights. So we see that ILO law, but also human rights law, would not come up with such a distinction. And most importantly, and this is obviously very relevant in the context that we are discussing this, and it already came up in the first 2 interventions. Of course, the CAI has to be seen in the context of the EU primary law, specifically the EU's own obligations stemming from the Treaty on the European Union, and Article 21, paragraph 1 of the Treaty on the European Union underlines the universality of human rights. So it would seem to me that even from that perspective, it is highly critical that the EU comes up with this distinction between those different types of core labor rights. Now, I think I see why politically it would have been almost impossible maybe to ask China to ratify, to specifically ratify also ILO Conventions 87 and 98. But it's very important to realize China has ratified the International Covenant on Economic, Social, Cultural Rights. So China is bound by those rights, those human rights, and those labor rights, which are part of the International Covenant on Economic, Social, Cultural Rights. And therefore, it would seem to me that one could have or should have pushed that even further, specifically since I would argue it would be an obligation of the EU based on Article 21, paragraph 1 of the Treaty on European Union law, on European Union, sorry. My second comment I want to address to Sang-Jin's wonderful presentation of the EU-Korea panel report, which is of course very interesting, very fascinating. Many of us have argued that these questions whether these trade and sustainability chapters will ever have an implementation, and we were actually surprised to see, I have to admit, I was surprised to see the relatively strong language and the very good legal analysis that the panel came up with. What I think is interesting, and Sang-Jin highlighted that, the language that we see in the EU Korea Free Trade Agreement and on labor, of course, and the language that we see in the CAI seems to be relatively similar. So from that perspective, one could argue that maybe in a couple of years, if the agreement ever is ratified, we still don't know that, but if it ever is ratified and if there ever is going to be a proceeding, then maybe one could see a similar development in which a panel would also look to Chinese efforts in the same way it looked into, in the same way as the panel looked into the Korean efforts. But to me, there's a fundamental difference. And maybe Sang-Jin wants to comment on that as well, because I'm obviously not an expert in Korean law and Korean constitutional law or Korean labor law, but it seems to me, this is at least what I read, the panel proceedings, when they were started in 2018, were also started, or need to be contextualized, I should say, need to be contextualized in a domestic Korean debate on labor law reform. I think Sang-Jin made that very clear. So one could argue the panel sort of helped maybe domestic players in Korea to actually push a move that was already there even further. And it helped sort of the domestic labor unions and those political parties who pushed this forward. Now, this is an impact of sort of international panels that we often see in many contexts, but the contexts have to be, of course, democratic and open societies in which there are these dialogues, and in which societies in which domestic players can positively relate to international obligations. No, I'm very, I don't know, I have to say, whether a similar effect could be seen in the context of China. So that's a question that maybe also others in the audience can answer. But I think it would be important to keep that in mind if we have similar provisions in the CAI than in the EU-Korea Free Trade Agreement, that the context in which arguably the EU-Korea panel operated is vastly different than the context than any potential EU-China panel would operate. And then lastly, maybe just a question, maybe back to Dominique. I don't know what I thought was interesting also in the debate that we had so far, and also what we heard at the very beginning, is that of course there are severe issues when it comes to human rights and labor rights in China. What about environmental rights? I mean, the question would be, how difficult will it be actually for China to accept or to implement also the obligations that it is undertaken under the in the environmental chapter. So I guess the more broader question would be, do we see a similar maybe divergence between the EU and China in environmental law than we see in human rights law and labor law, or is it actually more of a convergence? Is there maybe an increasing understanding of the importance of environmental law, the importance of climate change, and those? So that's why maybe the situation when it comes to environmental law and regulations could be different than the situation when it comes to labor law and regulations. Because of course also this would be interesting to see in the context of the ratification process. I think so. Those were the comments that I wanted to make, Julian. I hope that I lived up to the expectations that you had for me as commentator, and I look forward to, of course, any questions and the debate.
Thank you very much, Marcos. These are fantastic comments and questions. I think would be great if our three speakers can perhaps answer or comment on the comments before we take some further questions from the colleagues in attendance. There are many questions coming in. Can I simply ask, say, Axel, Sungjin, and Dominique to react to Marcus' comments and questions and give quick feedback in 2-3 minutes, so we can have a second round of Q&A. Let's start with Axel, perhaps.
Thank you very much, Julia, and thank you very much, Marcus. Actually, do not have to add much to Marcus's comments, in the sense that to a degree it reiterates the point I wanted to make, that the ILO core conventions are not mentioned exactly in the same way as they have been mentioned in previous agreements. There is this hierarchy. There's this very subtle language in which things are introduced. And I can only agree with Marcus that I can see also, of course, the political logic behind it. And I was not in the room. I can imagine that there are a lot of discussions on how you draft the specific words and sentences and so on. But it's clear that, let's say, the standard blueprint approach of what the EU normally does, and which was actually also shown in the slide by Sungjin, was not applied in this case. So they had to basically, I think, negotiate over every sentence and word to come to some kind of a resolution which would still include a reference to the ILO core conventions, but not as explicit as it's been in many other agreements. So that's just my brief feedback on Marcus' comments.
Thank you, Sungjin.
Okay, thank you very much, Professor Krajewski. I remember that we met before at some seminars before, and thank you very much for your comments. But anyway, I completely agree that this dispute between Korea and the EU must be understood in context, especially when it comes to the comparative understanding with the CAI, because as you know, political system in Korea and China are very different. And Korean government actually had a very hard time to convince all the stakeholders in the labor reform. And Korean government actually often uses such international dispute as an excuse to push for the reform of reform or some agenda for law amendment. And I think that especially the Korean Ministry of Labor, used this as a great opportunity to convince, especially the business side, to accept the ratification of the ILO Convention as well as amendment of the labor law in order to accept the more widely accepted definition and the membership to the trade union. And I think that so when it comes to the CAI context, I strongly agree that Korea's experience may not be applied the same manner as to the China's context, and especially as we see in the Xinjiang issues. I'm very, very doubtful that China will at least in the short term ever respect their obligation under the Section 4 of the CAI, at least for a short term. Of course, we'll have to see, and we'll have to see how it develops. But one positive thing is that China at least accepted the similar language in the CAI as the Korea-EU FTA, and it may also be a good. It may also be a very humble starting point for the further reform of China's labor law. But of course, it may take some time, and it may take, and therefore we should not lose hope for such midterm or long-term change. Thank you.
Very wise comment, Sung-Jin. Can I just ask you, when was the Korea-EU FTA negotiated? When it was signed?
It was signed in 2010 and ratified in 2011.
Okay, so basically it took 10 years between the time the text was agreed and that decision, which has to be understood in context, but a context that perhaps 10 years earlier could have never been predicted, right?
Right.
Okay, interesting. Dominique. Dominique, you are muted again. Twice. It's yellow card. I'm kidding.
Thank you. I want to think that China's economic growth, which is acknowledged globally, has come with environmental problems, including indoor and outdoor pollution, water shortage, and pollution, desertification, and so forth. So I would want to think that there will be more of a convergence between, I may be wrong in my thinking, but I would want to think that in light of the environmental issues that have come with China's economic growth, there's more likely to be, a convergence between the EU and China than a divergence on that issue. At least if the environmental issues are taken seriously. That would be my brief response to that. Thank you.
Thank you, Greg. Look, we have an extra 17 minutes for questions from the attendees, and there are many. So I've used the last seconds to arrange all that by groups, and we have basically 2 to 3 questions for each of you. So Axel, Sung-Jin, and Dominic. Let me start with Alex. So in the chat box, someone is simply asking whether there is any hope for the labor law in China to be amended in the context of the CAI. Well, you might want to react to that. That's perhaps also something on which Sung-Jin might want to comment on a little later. Second question for Axel. How would you assess the development of the EU toolbox to protect labor rights using both bilateral instruments like the CAI and unilateral instruments? Would be interesting to have your views on that. Comes from the chat box too. I'd like to add one question from myself, which is a follow-up, in fact. Look, I think that the CAI is to be understood as only one component of this EU toolbox for dealing with China, which also includes the WTO, ILO frameworks, sanctions, and this proposed regulation on corporate due diligence and corporate accountability. So my question on that, Axel, would be whether you think that this proposed regulation on corporate due diligence and corporate accountability is important, as it seems to seek to end forced labor in supply chains by imposing tight control on EU companies operating in China. For Sungjin now, quickly, Sungjin, I'd like to ask you a clarification on a few points with respect to the panel of experts. Very simple questions. Does the ruling, it render, have to be public, or could it be kept confidential? Second question, I think you had mentioned that the panel ruling is subject to follow-up consultations. I'd like to know what that is, follow-up consultations, or more generally, what we can expect from Korea and the EU in terms of interactions after this January 21 ruling. Also, Sungjin, towards the end of your presentation, you said that the Korean government used this case, okay, to advance a domestic agenda. I want to know whether there was somehow a need for Korea to accept anything in order to get the panel established. So we are back to the procedure here. And of course, we think about China. The question would be, could have Korea blocked the establishment of this panel of experts, and could China block the establishment of a similar panel? Turning to Dominique. Dominique, I'd like to speak about the dispute settlement. For the time being, the settlement of disputes in the EU FTA, so not only the CAI, but many other trade agreements that also cover sustainable development, environment, have dispute settlement mechanism which are separated from the other chapters, notably IP rights, trade, and the others. So is it something that weaken the credibility of the environment standards or sustainability standards in this new generation of EU FTAs? And should we, or should scholars and policymakers, some of them, argue for a single dispute settlement mechanism applying to everything under the trade agreements? And the very last one that I noted here, Dominique, I get the sense that you think that the CAI does more for sustainable development than usual trade or investment treaties. And in any case, the CAI does much more than existing BITs between EU member states and China. I think I'm correct on that. Now, could you point out, I'd say, the three most important concrete issues that are really not just novel, but significant upgrade in the way the CAI handles environment issues? Thank you. Let's start with Axel.
Thank you very much, Julia, for the questions. Let me take them one by one. One on whether the Chinese labor law will be amended. I think the chances are very unlikely that will happen as a direct response to the agreement. I think if some changes would have been expected, the EU might have tried to push or get them before the agreement was in principle agreed upon, rather than now wait and see. We will see how the follow-up and the monitoring of the provisions will take place. But in any case, the current approach does not, I think, allow for much, let's say, direct impact on Chinese labor law. So if there will be amended, it will also partially because I think internal dynamics and other reasons. So I don't expect a big impact of the agreement in that respect. Now, let me take the question by Julien and Mathieu together. On the one hand, the bilateral, on the other hand, unilateral approaches and a possible due diligence law. With regard to the bilateral approach, what I tried to make clear in the presentation is actually that the current approach in the agreement is, let's say, a weaker or watered down approach than what has been applied in other agreements. And actually the other agreements have already been criticized quite heavily for not having very strong enforcement potential in terms of the trade and sustainable development chapters. That's actually one of the reasons why the Commission wants to review that and strengthen that, also because there's clearly a very strong push from the Parliament, from civil society to have very strong commitments on that. And the agreement does not live up to that, I think, at all. So there's little to be expected from that. On the unilateral aspects, and especially a possible proposed approach to due diligence, I think that's still wait and see what will happen, and wait and see on two accounts. One is what will the Commission come up with a due diligence regulation? Will it mimic a bit the French approach, which targets large companies and has this vigilance law? Will it mimic maybe more the Dutch approach towards what they're trying to do with child labor? That's still wait and see, and very much will depend on how strong these regulations are designed, what the focus will be, what the implementation mechanisms will be, what the due diligence requirements will be, and so on. Having said that, one has to take into account that some EU member states have taken already these types of initiatives, but there are also many EU member states who are not very, let's say, pro these types of approaches. And there might be a little bit of a, let's say, a watered down version of a due diligence law. We have to wait and see what comes out of that. But that's still in the air. And I think by June, we will know more. I think by June, the Commission will make a proposal. Then secondly, related to a due diligence law, is to see what the effect will be in China. If you have been following the news over the weekend, there was quite a bit of news of companies like H&M and others, which were actually blocked in China because of some of the statements they put out. And these are typically the European companies which should implement such a due diligence requirement and should then install different measures to come up with, inter alia, some of the core conventions of the ILO, but then implemented on the company level and so on. So there it's also to see what the reactions will be in China. And then finally, with regard to a possible due diligence law, is also the applicability to investment as such, and maybe that it might be only be applicable to trade, but that's we have to see. Of course, if we talk about unilateral measures, the US, with its ban on cotton, tomato, and so on from different Chinese provinces, uses quite a strong unilateral instrument, and that's just blocking access to its markets if there is not compliance with a certain set of rules. So that might actually be also one way to go, but that's of course highly sensitive and highly strong political move.
Okay, Julian's question mostly focused on the procedural aspect of the EU-Korea labor dispute. And basically, if you take a look at the Korea UFTA Chapter 13, the consultation and the dispute settlement provisions are not very comprehensive as a CAI. And I personally understand that the procedural framework of the EU-Korea FTA largely used the Korea UFTA's dispute settlement provisions, especially the arbitration procedure. And also, if you take a look at the procedural understanding published by the European Commission. European Commission said that you publish its first written submission on its website, which the European Commission did, but Korea didn't. In this, and then the publication of the panel report, I think it was already agreed by both parties and so on. So because of the nature of the panel as a similar, which is similar to the arbitration, I think that Korea and the EU agreed to follow the Korea UFTA's arbitration procedure, state-to-state arbitration procedure, when it came to the unwritten parts under the Chapter 13 of the Korea UFTA. And of course, I don't have the first-hand experience of the matter, and therefore this is only my personal view. Thank you.
Thank you. Dominique, you again. Dominique, you are muted. You do it on purpose. We still can't hear you, Dominique.
My apologies. I have problems with the mouse. There's a problem with the mouse. So when I'm trying to get to the appropriate place to click, it's just running around. So. No
problem. We'll remember. Yeah. It's a wild mouse.
Yes, your question on the separation of the dispute settlement mechanism, that's an important question, and I'm happy to address it. Now, you will see that when it comes to investor-state dispute settlement, there is certainty as to the processes and procedures and how they go about resolving dispute between states and foreign investors. And there's certainty as to the enforceability of those provisions. We don't find the same thing necessarily in the case of state-state disputes. We don't find certainty and predictability and enforceability provision when it comes to, say, for example, the provisions on how to resolve sustainable development and issues under the CAI, for example. So then the question arises as to how effectively the dispute settlement mechanisms that have been put in place to address environmental issues can be efficacious. So my view is that if we have enforceable obligations against foreign investors under investment treaties, then those states should be able to raise issues before investor-state tribunal, assuming we continue to use that mechanism against foreign investors. Alternatively, if we feel that state-to-state mechanisms are the effective way to deal with environmental issues, then again, we need enforceable obligations that states can take to the dispute settlement bodies that can resolve, make decisions that will be binding on foreign investors to act on. So, yes, the separation can weaken the protection of the environment in the sense that currently the regime regulating the resolution of, say, the sustainable development differences are such that their enforceability is in question. And so I think that that's a legitimate question that you have raised there. Now, in terms of the three most important provisions in CAI that I have identified that really will contribute to addressing environmental concerns, I think that is to be taken seriously, because at the end of the day, it is about what foreign investors manufacture. It is about their operations that raise environmental issues. So if we can ensure that indeed the operating activities of foreign investors, their manufacturing processes are done, the products that they come out with are, environmental friendly, then we can be addressing environmental problems in international investment law. So I think that provision is crucial, which needs to be given maybe operative effect. There's also provision on the exchange of good practices and experiences when an investment is likely to have a significant impact on the environment. So again, at the point that the investment is being undertaken, depending on the nature of the investment involved, the host state may be aware of that investment that is going to be undertaken in a foreign jurisdiction and the nature of the environmental issues involved. Or it may well be that the host state that is receiving the investment and that has received the investment proposal will be in a position to be able to determine the nature of the environmental impact of that particular investment activity. So at that point, there is room for the state parties to cooperate on how to address the environmental issue before. I am suggesting that in that case, the environmental impacts should be assessed and determinations made as to how the environment will be protected before the foreign investor is actually admitted. I think there's another, yes, and then there's a provision in section, let me see, Article 2, subsection 3 of subsection 1 of section 3 of the agreement. And it says that in establishing the rules for licensing enterprises and admitting them, each party may take into account legitimate public policy objectives, including consideration of health, safety, and environmental protection. So I think that if at the point of admission, states could utilize this provision to say that, look, unless we are sure about how your operations are going to account for environmental harm, environmental damage, that is incidental to or characteristic of the nature of the investment, there will be no admission. I think that will be one way that states could actually address environmental issues using these kind of provisions. Thank you.
Fantastic. Close to the end. I thought I should share with you this very interesting investigation, pretty comprehensive, published today in the South China Morning Post, which is Hong Kong newspaper in English, which seems to suggest that after tomato, cotton, there may be something else coming up. So I encourage you to take a look at that. I also do not want to ignore one question which was formulated by a colleague. The question was about the schedules, the list of schedules that were published on March 12. And the question is about how we would evaluate them and the role they can play in the ratification process. Well, market access was something we discussed last time, so I don't want to embarrass any colleagues and put forward that question to anyone. If I may, I'll just try to answer it in 1 minute. I think that to evaluate the recently published schedules, that's going to take some time. There have been a few articles on media, for instance, and the like, but it's huge. I think the way to proceed, I will limit myself to the methodology, would be first to compare what's in to the WTO and the GATS-MO 3 in particular. Also, we have many people based in Europe. Would be very important to remind you all of the importance of the RCEP, which was signed in November 2020 by China. And so I would be very interested to compare the CAI schedules of commitments to the RCEP schedules of commitments, and only after that, after this mini comparison, we could really tell whether the CAI's commitments go beyond, much beyond, or not beyond what's already exists elsewhere. But for now, I'm not aware of anyone who has done such a tedious exercise. But that will play a role in the ratification, I think, because the issue will remain around for some time, and that will force the Commission to justify a number of choices made in these commitments. So that's going to, I think, become an important issue during the ratification process. Say ratification broadly understood. All right. So excellent. I truly enjoyed this first session. We took an extra 3 minutes on the program, which is quite all right. I'd like to thank again our speakers for their very interesting and stimulating contributions. That's why we have so many people in attendance. A fantastic time management too on the part of everyone. So it's time to close this session 1. And if I may say, back to London, where Mathieu is. Mathieu will be chairing the second session that we start without transition.
Many thanks indeed, Julien, and really great thanks to all our speakers and discussants for the first session. I have no doubt that our speakers in the second session will meet the same standards. So very warm welcome indeed to our speakers and discussants for this second session, which will focus on the ratification process by the European Union and China. We have here again scholars who join us from different parts of the world. So I would like to welcome here Professor Claudio Dordi from the University of Bocconi, Italy, Professor Kolja Reuber from the University of Leuven, Professor Li Bin from Beijing Normal University, as well as our two discussants, Yan Xiaohua from Fudan University and Professor Men Zheng from the Dalian University of Technology. I will not take too long to present the different speakers and discussants. You can find their web profile online. And before we start, I just would like to remind everyone that you have the chat on which you can ask any questions you may have. And as Professor Li unfortunately has to leave us at 6:30 Beijing time, I would suggest that we proceed in the reverse order and that we start with Professor Li for his presentation on the China ratification process. So please, if you have any questions to Professor Li, please raise them on the chat as soon as possible so that he will get the possibility to answer those questions right after his presentation. So Professor Li is a professor of public international law at Beijing Normal University, but he's also very well known for creating bridges between China and Europe in general, but also China and France in particular. Professor Li indeed wrote his PhD in France and has been keeping very close ties with the academic communities in France and beyond ever since. So Professor Li, Sherbin, many thanks for having accepted our invitation, and the floor is yours for the coming 12 minutes.
Thank you so much for inviting me to this very interesting seminar, webinar. So I will share the screen with all the participants. So my topic is the China ratification process. I think this subject is very closely connected to domestic law. So if we look at the ratification or approval procedure as required by the agreement, Section 6, subsection 2, Article 18.
Bin, sorry to interrupt, just to say that we cannot see your screen. I mean, if you were willing to share slides, we cannot see it yet. So just to make sure that we are
okay
from a tech side.
I will.
So you just have to click, share screen.
Yes, I forget to this one.
Now we can see it.
Yes, thank you.
You're welcome.
Thank you. So Article 18 of the Section 6, subsection 2 states that the agreement shall be approved by the parties in accordance with their own procedures. That's it's a reference to the domestic law. So when I look at the Chinese law on the procedure of the conclusion of treaties, I should say that ratification and approval are two different procedures. So let's look at first Article 7. Provides that the ratification of treaties and important agreement shall be decided upon by the Standing Committee of the NPC. And also Article 7 enumerates all the important, so-called important treaties and agreements which shall be ratified. So I will not dwell upon this enumeration. And Article 8 provides that other agreements or instruments having the nature of a treaty which do not fall under paragraph Second, Article 7 of this law, and which are subject to approval as required by the State Council or as agreed by the contracting parties, shall be submitted to the central government, the State Council, for approval. So this is an example of RCEP, the Regional Comprehensive Economic Partnership. I consulted the website and the news report. It is recently stated that the central government, the State Council, has finished the approval procedure of RCEP. So very probably the CAI, the Comprehensive Agreement on Investment between EU and China, will also follow the same procedure of government approval. So let me explain the aim and the purpose of approval procedure. There are 2 points. First, I think for the approval procedure, it serves the purpose of ensuring or verifying the compatibility of domestic laws and the regulations with international agreements. And the means for ensuring that the verification is to adopt rules or revising the current domestic rules and regulations which are not compatible or maybe conflict conflict to the international agreements. So this is one of the main purposes to ensuring or verifying the compatibility. And also substantially, I think the approval procedure serves as a departure point for preparing the implementation of the agreements. As many speakers have already observed, we share generally a concern that whether the CAI could be effective in the implementation process. So more regulatory and institutional, or even some training measures should be adopted for the implementation purpose. So the approval, the government approval, is just a starting point, a departure for preparing through adopting regulatory, institutional, training measures, etc., etc. So next, if we look at the obligations contained in the comprehensive agreement, I should say there are 2 main sets of obligation which constitute the cause of a future implementation. If we do not consider the open issue of the transparency of subsidies, because there is no publishment about the rules relating to the transparency of subsidies until now. The first set of obligation is schedule of commitments and the reservations. As someone from the audience has observed that the recent publication of the schedules of commitments and the reservations by China is not regarded as so important, as China has probably made the promises during the negotiation process. So I think from this point of view, the approval procedure could be much simple or facilitated because of the less complex issue contained in the schedule of commitments or reservations. So there are several observations. First, for China, I think the preparation of schedules may, to a large extent, cover or overlap with the government approval procedure, or at least the 2 steps are very closely intertwined. A second observation is EU ratification could be more complex than China approval procedure because the latter, for the China's ratification or approval procedure could be more straightforward or simplified. In other words, the implementation of CAI starts with approval process, at least insofar as China is concerned. But how CAI is approved at the national level decides or determines to a large extent the quality of the future implementation of the agreement. So this is the first set of obligations relating to commitments and the market access commitments or reservations, etc., etc. And the second set of obligations, which is a more crucial for the agreement, as Professor Shes has already observed, is one of the most advanced aspects of the current aspect of the investment agreements. That means the regulatory framework and the sustainable development goals. Even though, according to the current agreement, regulatory framework and sustainable development goals are separated into two sections. But I personally believe that the two sections are very closely connected. But they share many questions. For example, first is the objectives of SDG goals, how to achieve the standards, methods, mechanism of assessment, and monitoring, etc., etc., as many speakers has already observed. And second, in the section relating to sustainable development, there are mentions about the responsible business practices. For purpose of implementation, policy and the rulemaking activities at national levels are required. Similarly, there is a mention about the investment committee, but the role and the status of the function of this investment committee is not so clearly defined. So probably it should be strengthened afterwards. That means after the conclusion of the agreement. My question is whether after the conclusion, there will be some open-ended or constant negotiation in order to clarify or strengthen the status and the role of the investment committee, or probably there will be a joint monitoring mechanism to perform a minimum degree of control about the achievement of sustainable development goals. And the fourth point, there are mentions about the investments of relevance for climate change mitigation and adaptation. So a policy framework is also required. Similarly, for investment and labor, many debates has already discussed. There are mentions about the efforts for China to ratify the ILO conventions number 29 and 105 about the forced labor. And also investment policies are required for favoring decent work, etc., etc. There are mentions about the special mechanism for dispute settlements relating to SDGs. There are provisions on panel of experts, amicus curiae, submissions, and all these provisions, the implementation of which require further institutional arrangement at domestic level for the Chinese government one. There are approbation procedures to be adopted. So according to the second, relating to the second set of obligations, my observation is, first, there is close connection between sections 3 and 4, and they should be further tightened because regulatory framework and SDGs embodies a combination of so-called upstream flow and the downstream flow of the legal regime of international investment. That means investment treaty or investment agreement could influence the change, the modification of domestic law. But on the other side, domestic law determines the quality of implementation of investment agreement. So there is a combination of the two sides, upstream flow and the downstream flow. But whether the SDGs of the CAI will be achieved or to what extent the SDGs could be extended depends more on the CAI's downstream flow with the national legislation and policies. So the first observation will lead to the second. So my question is whether there will be a continuation of interstate engagement between EU and then China after the conclusion. That means the conclusion of the treaty's agreement is only the first step. and there should be some following steps to be continued. Probably there will be more civil society's input and influence, as many speakers has already observed, the innovation of this agreement, which give more importance to civil society. So this is my very preliminary observation about the approval procedure and the future trend of the KAI at the domestic level. Thank you so much.
Thank you very much indeed, Professor Lee, for this very interesting presentation, which made it clear that even if the agreement has been concluded in principle, that a lot of clarifications are indeed still needed, also from the perspective of the follow-up on the domestic front in China. So I see that there is only so far, a question for you on the chat, which I will relay to you immediately, and I will also abuse my position as a chair to also ask you a question. So for you, Professor Lee, first question, could recent Chinese sanctions affect the Chinese ratification first? And second, could approval procedure you described, be stopped? If yes, at what point? And could it simply be cancelled or suspended? So indeed, a number of events in recent days, and can those tick-for-tack sanctions have an impact on the ongoing process, which has already started? And if I this would be a first question for you, and then I'll see whether I have other questions on the chat afterwards. So please, Bin, the floor is yours.
So if there are no other questions, I will share some observations with you about the political dimension of the ratification approval procedure. To be very frankly, if we compare RCEP, the Regional Comprehensive Economic Partnership, and the KAI, both from the official side and the news report, I can find very hardly any detailed discussion about KAI, but many attention has been drawn to the RCEP. So I think the future for KAI is not so bright, at least compared to the RCEP. And also another news I should share with you. Until now, I have no so-called official translation, the Chinese translation of the KAI. I can get access to the English version and some non-official translation of the agreement. But compared to the RCEP, it's very different. So from this aspect, I think the future of KAI, especially from the perspective of ratification, is not so bright. I'm sorry.
That's a very interesting point indeed, and it stands very much in sharp contrast with what we witnessed with the RCEP, right, where China very much took the lead in the ratification process and pushed very much indeed for the follow-up ratification by other parties to the KAI. If I may, just one follow-up question, Bin, and it relates indeed, to the absence of investor protection mechanism, which is at the moment not included in the article as it was concluded in principle. The EU and China both committed to pursue the negotiations on that front, and my question for you would be whether the inclusion in the future of such an investor protection mechanism would impact, or in whatever direction, the ratification process on the Chinese side, depending obviously on when indeed an agreement on such an investor protection mechanism was to be found.
I think it's a very hard question. My analysis is that China and the EU, and especially EU member states, also should reflect over the relationship between the KAI, the future investment agreements, with the current investment agreements already concluded between China and some European Union states. So how to treat the relationship between the old BIT and the new KAI could be a pathway for integrating the ISDS investment dispute mechanism. So if suppose there is no new special mechanism for the dispute settlements in the CAI, both EU member states and China could refer to the old investment agreements. So this is my personal opinion. I don't know the strategy for the bilateral negotiation on the dispute settlement issue, but at least there are many attention being put to this issue because this is a quite important aspect of the investment law legal regime. So there is many discussion. So I'm not sure whether there will be a truly innovative dispute settlement to be put into the CAI. Thank you.
Thank you so much, Vin, and again for making up some time to be with us this afternoon / this evening. So you have to go now, I know, but just would like again to extend
I'm sorry
my
for
gratitude
earlier because I have to teach at 7 p.m. here. Thank you so much, and also thank Professor Shes for sending this news report. But unfortunately, I cannot open it because it shows that this news contains illegal information, unlawful information. I'm sorry. See you. See you.
Thank you so much, Vin. Wish you a very good evening. And now, without further ado, it's time to move on to our next speaker, Professor Claudio Dordi from the University of Bocconi in Italy, who we asked indeed to make a presentation on the experience, on the ratification experience of another agreement, which is indeed the EU-Vietnam FTA, which was also an agreement which raised a number of issues, not least in view of human rights and labor rights protection. So Professor Dordi kindly accepted indeed to share with us what his analysis of this experience is all about, and indeed how it may indeed inform the upcoming ratification process of the CAI. Professor Dordi, many thanks for being with us, and the floor is yours for the coming 12 minutes.
Thank you very much. I hope you can hear me. And okay, let me introduce first the European Union-Vietnam Free Trade Agreement. The negotiations started in 2012. The negotiations informally concluded in 2015. And then they started doing the so-called legal scrubbing, which was quite complicated because the negotiations were really difficult on several topics. Then we had the opinion on the EU-Singapore Free Trade Agreement. And following that, the EDFTA was divided into two parts, the trade agreements and investment partnership agreements. So we have indeed the free trade agreements between Vietnam and the European Union. Well, the trade agreements are two, one on investment and one on trade. Let's move. I assume that this could be a good lessons for the ratification procedure, especially in the European Union, of the China-European Union investment agreement. And it's a good lessons learned because the European Parliament especially raised the concern about the ratification of the agreement. We can summarize it based on our topics, on two different topics. First of all, issues related to the text of the agreement and commitments or obligations arising from the agreement. And we may say topics are beyond the text of the agreement. With regard to the issues related to the text of the agreement, especially the concerns of the Parliament and of the civil society in Europe were focused on the implementation of the commitments regarding the trade and sustainable chapter, especially the part related to workers' rights, labor rights. The environmental parts raised lower concern among the civil society. On the other hand, however, we had several concerns regarding the topics beyond the scope of the agreement, and especially topics related to human rights in general, as testified by the concluding observation of the Human Rights Committee of the Convention on Civil and Political Rights, Covenant on Civil and Political Rights of the United Nations, but especially by the opinion of the Committee on Foreign Affairs of the European Parliament on December 5, 2019. It's very interesting to note that, and I like to read it because it could be really relevant. The committee, the Committee on Foreign Affairs, strongly believes that improvements are necessary on December 2019 in Vietnam in the areas of the rule of law, good governance, sustainable development, and respect of human rights, and called the Commission to formally report to parliaments on Vietnam's commitment to progress on a series of human rights issues, as referred to in a previous resolution. And consider, and especially the last part, the last paragraph 15, considers that consent should be given to the agreement only if the Vietnamese authorities release their political prisoners, stresses the need to commit to and agree with the Commission on a clear timeline for taking effective legislative and non-legislative measures to address the concerns set out in these resolutions. Calls on the Commission to address these concerns. Said that, December 2019, I recorded here on July 2020, the Parliament, after in February, the Council approved the agreement. July 2020, also the Parliament approved the agreement, and the members voted for the FTA by a majority of 401 votes to 192, with 40 abstentions, similar to the majority which approved the IPA, the Investment Partnership Agreement, 407 against 188, with 53 abstentions. Of course, nothing could have happened substantially and substantial from December 2019 to July 2020. However, how it was possible, well, I make a premise. I'm not going into detail about the procedure of the EU ratification because there is a colleague that is going to describe it later. But what happened? What are the reasons why, from our point of view and the point of view of scholars, convinced the Euro Parliament to approve the agreement with Vietnam? Well, the point is that there is an interesting point to be pointed out. First of all, you know that with regard to all the obligations arising from the agreement, so from the Trade and Sustainable Chapter agreement, and especially those obligations focus on labor rights. And I take it from the website of the ILO, Vietnam ratified several international conventions which were mentioned, clearly mentioned in the Trade and Sustainable Chapter of the agreement. In particular, the Right to Organize and Collective Bargaining Convention, Convention C098, the Convention of the Abolition of Forced Labor, plus all the other, several other conventions that were already approved and ratified by Vietnam in the past. Said that, there was still one important convention remaining out, which was the Convention on the Right of Association, the famous convention number 80. Sorry, I forgot the number. However, the Convention on the Right of Association. What happened with this convention, and what was one of the elements that convinced the European Parliament to approve the agreement? Well, Vietnam modified its labor law, labor code in 2019. And in the labor code of 2019, a sort of right of association for creating trade unions, which are not under the control of the Vietnam General Trade Union, which is the trade union under the strict control of the central party, was introduced indeed in the new labor law of 2019. But what was the main determinants, the main reasons why Vietnam decided to modify the labor law? Certainly was not, and even the European Union negotiators admitted that, certainly was not for the text of the Trade and Sustainable Chapter Agreement, the part dedicated on labor rights of the Free Trade Agreement. Indeed, if you have a look to the Free Trade Agreement, and scholars discussed it in detail in the last years, we have here that the parties endeavor, the language used by the agreement is the party endeavor, each party reaffirm its commitments in accordance with the obligations of ILO and ILO Declaration of Fundamental Practice, of fundamental, principles. And again, the party reaffirms their intention and their commitment to proceed the ratification of all these conventions, etc. As you can see, the language is not mandatory. So, and this has been already clarified several times. However, the lucky position of the European Union was that at the same time Vietnam negotiated the European Union-Vietnam Free Trade Agreement, Vietnam negotiated the Trans-Pacific Partnership with other 10 other contracting parties, 11 to tell the truth, including the United States. And within the negotiation of the TPP during the Obama administration, Vietnam and the United States agreed on a specific sub-agreement, bilateral agreement in the form of exchange of letter, where Vietnam didn't, you know, the United States in their agreements, they are not really interested to promote the ratification of specific ILO conventions, but normally the US, at least in the past, prefer to invite and, or better, to oblige the other contracting party to commit, to specifically commit on specific rights, which are also eventually protected by ILO convention. And in this exchange of bilateral letters between Vietnam and the United States, the right of associations was mentioned, and the language used was really mandatory. If you look to this exchange of letter, you can see a lot of reference to shall and not endeavor to. So following the conclusion of the Trans-Pacific Partnership negotiations, Vietnam started the procedures for revising the labor code. But what is really interesting is that even after the United States decided not to proceed further with the Trans-Pacific Partnership, Vietnam continued to modify the domestic labor code, and in the end, eventually modified the labor code, introducing these sort of rights of associations independently from the control of the party. And the labor code entered into force the 1st of January of this year, 2021.
Professor Dordi, sorry, just if I may kindly ask you to move on slowly to your conclusions, please.
Yeah, we are almost to finish.
Thank you so much.
The good lessons learned is here that first, Vietnam, you know, the European Union might have benefited from the action of another international actor negotiating with Vietnam this kind of rights, and this is first. Secondly, we think that Vietnam figure out and picture out its situation not as a picture at a certain moment. I mean that in several discussions and presentations by politicians, Vietnamese politicians, Vietnam admitted that if we take a picture of the situation of human rights and worker rights in Vietnam, well, worker rights, okay, but human rights in Vietnam in 2020, you might not compare it with any other industrial countries, Western countries. However, if you have a look to the movie of Vietnam from 2010 or even 2005, 2007, when Vietnam access to the World Trade Organization, up to now, you can see substantial improvement in the protection of human rights and other fundamental rights in Vietnam. And that's the way likely Vietnam was able to convince most of the European parliamenters, parliament members to approve the agreement. And I would like to conclude with this statement from Melinda Taylor, which is a European Regional Forum Liaison Officer of the International Lawyer Association, International Bar Associations. The agreement, she mentioned that the agreement is thus built on future promises to adhere to key human rights standards, rather than a concrete record of compliance. And I would close here. Thank you.
Thank you so much, Professor Doherty. I mean, putting, the EU-Vietnam experience in context the way you did it, really shows that we should also look beyond the very wording of the CAI if we are indeed to understand the prospects, but also the challenges towards a ratification. So many, many thanks for that. And just a kind reminder to the audience that you can ask Professor Doherty and his fellow panelists questions using the chat. It's now time to move on to Professor Kolja Reuber from the University of Leuven. We'll talk about the prospects, but also challenges for the EU ratification process. Kolja is definitely the right person to do so, not least in view of his expertise on the role played by the European Parliament in the EU's external trade and investment policy, and also in view of all the work he's done on the on issues relating to coherence in the EU's external action, which is indeed an important component, as we could hear from Ms. Vedren's presentation this morning, when the ratification of the CAI is concerned. Kolja, thank you again so much for being with us, and the floor is yours for the coming 12 minutes.
Thank you very much, Mathieu. I will upload my slides so that you can have a look. I hope you can see already something.
We can see them, yes.
Perfect. That's very good. And now I will basically talk about I hope I can reduce this. Yes, now I'm starting. So thank you very much for the invitation, and I'm very happy to be here. Let me talk about something that I call the shadows of the future and the shadow of the present, the challenge for the approval of CAI. And I will contextualize a little bit my talk at the beginning. So when we talk about the EU's trade and investment policy, I think we have to contextualize it as the overall ambition to harness globalization, as one of the communication papers of the European Commission in 2016 said itself, and the trade for all approach that the European Commission put forward at the time. In the meantime, we have seen some new communications coming our way, but basically we see this push for bilateralism in the absence of effective multilateralism in the context of trade. So that has been one of the major ambitions. At the same time, we see a global context emerging, an increasing US-China power struggle that has been going on now for a couple of years, and that seems to even continue and perhaps intensify over the last couple of weeks. We see the EU-US relations and increased cooperation with the new incoming Biden administration. We see EU-China relations somehow hanging between cooperation and contestation. So this is, I think, the context that we need to keep in mind when we talk about the future of CAI. In a way, what we also see in the EU foreign policy context is that kind of ambivalent rhetoric by the EU to address China as, on the one hand, a systemic rival and at the same time an economic competitor, as of 2019 onwards. We see strategies coming from the EU, such as the connectivity strategy and such as a more geopolitical strategy emerging from September 2019 onwards. And all of that in the context of what the EU claimed to be principled pragmatism in its global strategy from 2016 onwards. Now, we also know that CAI has been willing to be signed. So we can see that with that willingness, China was approached as an economic competitor with whom you want to cooperate. And what made that happen was basically the prevailing idea for market access and something that I would call the interdependence between China and the EU, but also the increasing dependence of the EU on China. And that is, so to speak, speaking very much to the idea of harnessing globalization. Now, at the same time, CAI was scrutinized and was already criticized in December for not sufficiently taking into account non-investment policy aspects, such as, for example, human rights, which spoke much more to the idea of systemic rivalry, something that the EU had actually been put out there as a term, and something that I would call, and I will come back to that, the future, the shadow of the future. So if the Commission doesn't take into account what especially members of the European Parliament want, this may have a shadow that actually informs the decision of the European Parliament in the future. We should also take into account what has happened in the European Union over the last 2 years. The EU has a new action plan for human rights and democracy, and almost in parallel to CAI, has come up with a new framework for targeted restrictive measures to address serious human rights violations and abuses worldwide in December. And in the meantime, it has used this new framework to actually issue sanctions against China, as we all know. That has, so to speak, triggered a coordinated effort by the European Union, the UK, the United States, and Canada, again, addressing China much more as a systemic rival, and in fact, putting EU-China relations into the context of contestation, and underlining the increased transatlantic relations and cooperation with the United States. At the same time, we see retaliation now by PR China, sanctions against MEPs, the European Parliament itself, its Droit Committee, the Council with its Political and Security Committee, individual member parliamentarian academics in the EU. So also China is actually now relating to the EU through contestation. And in fact, we can perhaps also see that in the context of the increased power struggle between China and the US. What does all of that mean? What does all of that mean? I think we can see that retaliation in one way as now a reciprocity tool. Mathieu Bonnet has mentioned that, tit for tat, right? But we can also mention this as tit for tat plus. Tit for tat plus, because this retaliation now is really, so to speak, the shadow of the present for the European Parliament. It can divide the EU institutions and the member states, especially those member states that wanted to push for the investment agreement, Germany, for example. We can see it as a dividing tool for horizontal divisions between, on the one hand, the European Parliament and perhaps the European Commission that further wants to pursue this actually CAI agreement that it had negotiated. But we can also think about it as a dividing tool of intra-institutional divisions and incoherence. For example, what about INTA on the one hand and droit taking a different stand within the European Parliament on the other hand? And can we perhaps think about different lines within the European Commission? DG Trade on the one hand, and perhaps other DGs, the European External Action Service on the other hand. So the EU looks as if it has to make a choice between pragmatism and principles now. What does that mean for the ratification? The Council examines the proposal for conclusion and sends the agreement to the European Parliament for its consent. Now, this is a major game changer since Lisbon, because the European Parliament needs to give its consent. It is empowered. Article 218, as you know, of the TFEU is really giving the European Parliament that role. And it also creates some kind of asymmetric power relationship with the national parliaments, as long as it isn't a mixed agreement. When it is a mixed agreement, such as it would have perhaps been if ISDS was involved in K, then actually Opinion 215, the Singapore case, comes into the fore, and we would have had a different ball game with national parliaments involved. Now, basically, the ball is in the camp of the European Parliament, what people call the Sessin, the Anrufung des Gerichts, the verdict of the court, although it's a European Parliament, right? And here I would argue two things are happening now. We have the shadow of the future, which has to do with what had been negotiated and where the European Parliament found the agreement already very difficult to accept, at least certain camps within the European Parliament, while others said, well, okay, we can go along. But now the European Parliament is, so to speak, attacked by the retaliation measures, and that means there is a shadow of the present. So the Inter report, upon which the European Parliament will have to vote yes or no, still needs to be decided whether it can actually come, whether the European Parliament will actually, in the current context, deal with the CAI. Just to give you an idea how MEPs responded, some were basically saying, we will not be intimidated, we will not be silenced, it's a precondition that sanctions are lifted. That's what you hear from S&D. When you look at the Greens, they basically say, as long as these sanctions are in place, we cannot even consider putting the investment agreement on the table. When you look at the EPP, it looks a little bit different. And there seems to be this idea that perhaps you can still de-escalate the situation and perhaps compartmentalize or kind of vote on the CAI despite the sanctions. And with Renew, I think we've seen that there is a change going on towards also saying that it's a precondition that sanctions are lifted, but we can talk about that. What does that mean? What does all of that mean? And I come to my conclusions. I think it's really a question of dividing Europe or uniting EU institutions towards a coherent, pragmatic, and principled strategic action. What could actually now be happening is that the European Union is putting everything together finally in a coherent response and saying we cannot sign the agreement. Or the other option is that you go for two different approaches. One, which may look more pragmatic, that you stick to CAI, but where you basically follow another principled approach as well. Basically, I think the latter has happened to the whole difficulty that we are stuck with right now, that the European Union has basically been pursuing this on two different tracks. Let's call that the trade and investment track on the one hand, and it has pursued the human rights track. But the two have never really come together very neatly. It's the question whether this is now finally the case. And then the question is, are we at the end of the investment agreement? So we can perhaps argue that it is unlikely for the European Parliament at this moment to agree in view of the shadow of the future and the shadow of the present, sorry for the typo here, to actually sign this agreement, unless it is compartmentalized, unless it only, so to speak, speaks to certain issues of the agreement that are falling short of labor rights, of human rights, and that you keep the sanction case apart. But at the same time, as we know from CGEU case law, take the Tanzania case, the European Parliament has been almost addressed by the court as a guardian of consistency and needs to take into account coherence and consistency of different aspects of EU external relations when scrutinizing trade and investment. So unlikely, I guess, that the European Parliament at this moment will simply wash the sanctions question aside and basically will continue. There is another issue here, and that is that the investment agreement may also be unlikely to be signed, given the increasing transatlantic ties, which the European Union has pursued over the last couple of weeks, and where we see, so to speak, that the EU has been heavily criticized by the US for actually pursuing the KAI in the first place. So thank you very much for your attention.
Thank you very much, Kolja, for this very thought-provoking and comprehensive presentation. I won't try to summarize it here, but I did find it quite interesting to see how difficult it is indeed for the European Union to kind of bridge what you call the different Chinese identities from a European perspective, namely this idea of China as a cooperation partner, an economic competitor, or even a systemic rival. And I did find in that regard, indeed, the kind of theoretical or conceptual tools you offered quite interesting indeed to try to understand those challenges. So many, many thanks, Kolja. And it's now time to move on to our two discussants, who I would like to thank very much for being with us today. So Professor Jean Monnet, who is very much well known from most of you, who is a professor in European studies at Dalian University of Technology, but Professor Monnet has indeed been one of the main scholars in both China and Europe who has been dealing with various aspects of the EU-China strategic partnership. And then indeed we have Dr. Yan Xiaohua, who is a researcher at Fudan University, who has also done quite some work indeed on the EU-China trade and investment relationship. So many thanks to the two of you for being here. I would like to suggest that we start with Professor Monnet, and just a kind reminder to our two discussants, if you could stick to 3 to 5 minutes maximum for the discussion, that would be excellent. Thank you so much. Professor Monnet, the floor is yours. You are still on mute. Jeng, you have to unmute yourself.
Okay, so I forgot to unmute myself.
Now we can hear.
Thanks for your invitation, and congratulations for such a successful organization of this very short but very condensed and intensive discussion on KAI. I have to say that I don't have any legal background. This might be my shortcoming. I mainly observe KAI from a political perspective, and I like very much the presentations by all the scholars here, the Chinese professor, the Italian professor, and Kolja Rob from Leuven University. And they each provided a very different perspective. And the Vietnam case study might provide some good experience to the EU-China ratification of the KAI. But for the moment, we know that the political atmosphere is not very agreeable. It might be very difficult for the Chinese to take the experience from the Vietnamese side and then to go for the ILO or for the international covenants. But for the presentation made by Kolja Rob, I totally agree with all these difficulties that have been mentioned by you. And particularly, I think, well, in my point of view, indeed, all these points are very difficult, let's say, very difficult for the EU and China to overcome for the moment. But on the other hand, we also have to realize that when the KAI was concluded at the end of December 2020, the atmosphere was different from nowadays, in the sense that at that time, not only China, but also the EU and its member states were quite active in promoting the conclusion, because particularly the business sectors, the member states, the Chamber of China, EU Chamber of China, they are eager to get access to Chinese market, because that is the side of pragmatism. Because CAI in fact provides good opportunities for the EU businesses to go to Chinese market. And also on top of that, the Chinese government promised to a certain degree some of the contents included in the CAI, which were never included in any other international agreements that the Chinese government ever negotiated with the others. So in that sense, we could say that indeed the Chinese government was also very interested in making some concessions in getting this CAI done. But currently the atmosphere is totally different. In the previous discussions and presentations, we mainly talked about CAI from the European perspective. And even from the European perspective, we know that due to the sanctions, due to the disagreements, due to the statement from the EU side that China is a systemic rival, it's very unlikely for the EP to make any concession to just, go for the ratification. But from the Chinese side, I also think that it's very difficult. Just now, Professor Li mentioned very briefly that he didn't find any publications in recent months with regards to the discussion of CAI with CAI, how it should be ratified, in the Chinese decision-making process so clearly. And me, more from political point of view, I have to say that I have not found any positive signs either from the Chinese media, from the Chinese publications. So in that sense, we could say both sides encountered some barriers, which is very difficult to be overcome in the short term. In other words, even if the official documents would be translated into Chinese, because just now Professor Li said even there is no, up till now, there is no official document. But even if it's translated into Chinese in the coming months, I don't think the current situation will be favorable for Chinese government to consider for the ratification. And therefore, we should wait and see. Wait and see in the sense that towards the end of this year, what will happen? Because personally, I strongly believe that this CAI, this CAI, is mutually beneficial from pragmatic point of view, because Chinese market is not a small market. If European businesses can get access to Chinese market, this is certainly beneficial to many European businesses and investments. But on the other hand, of course, those non-human rights related commitments and regulations now become very influential, and also politically speaking, I think the content of CAI the discussion of content of CAI is more political than the content itself, than trade or business investment. And so all these days, what I heard is
if I may just ask you to conclude, Professor Venn, sorry.
Yeah, I would like to conclude. So that's why I'm not so optimistic as Kolya, Rob, as other speakers, that, the only thing we can do is to wait and see. But I insist that dialogue is still the most feasible way of communication and exchanges.
Many
Sure.
thanks indeed, Jing. If I may now move on to our next discussion, Dr. Yan from Fudan University. Dr. Yan, the floor is yours for the coming 3 to 5 minutes maximum, please.
Yeah, okay. Thank you, Masu. Thank you for the invitation, and I really enjoyed the presentations by the speakers. Since Professor Liebing has left, so I will just comment on the two speakers. First, on the EU Vietnam FTA case. I'm more interested on the economic side between the two cases, because for now, the CAI, the negotiation has been concluded. So the next issue is how to kind of sell it, both in China and the EU. And I have noticed an interesting difference between China and EU in this regard. While China has largely emphasized the economic benefits of the KAI, but also China has made concessions in the sustainable development chapters. But in the EU, it seems that the EU has largely used this CAI as a leverage against China, and the discussions has been largely focused on human rights issues. But what about the economic value, right? So I would like to ask the professor to comment about the case in Vietnam. So in addition to human rights, what about economic benefits? How was the economic benefits emphasized in the EU FTA, EU Vietnam FTA, and how that contribute to the ratification process? And also on Dr. Professor Collier, you talk about the broad context about the issue. I'm personally interested in the European Parliament's China policy, because you mentioned that China is using this as a dividing tool, but the fact is that the EU itself is very divided, and this is also the case in the European Parliament itself, because the European Parliament has not kind of formed a China strategy. While in the past, the Parliament does not have a say on trade and economic relations, so the EP can largely focus on human rights and normative issues. But now, after the Lisbon Treaty, the Parliament is also a co-decision maker in trade and economic relations. So now it's facing a tough choice. And I see also the Parliament is debating about this China policy. And I think the CAI kind of offers a good opportunity for the European Parliament to know more about China and to form a China strategy of its own. Because by debating about the CAI, I think the European Parliament may know that China is not just about human rights. It's also huge economic stakes there. So how the European Parliament will kind of find a balance between its human rights concerns and economic benefits. I think the CAI will provide such an opportunity for the European Parliament. Yeah, that's my comment.
Thank you very much, Dr. Yan, again, for those thought-provoking comments. I would suggest that we turn back to our two speakers, and just a kind reminder to the audience that you have the possibility to raise your questions on the chat. So Claudio, and I would suggest that we start with Claudio and then follow with Collier. If you could try to address those comments in 3 to 5 minutes each, that would be excellent. Thank you. Claudio, the floor is yours.
Thank you very much, Mathieu. I agree with Professor Jean Monnet. The Vietnamese example is not really too useful for the Chinese one for clear political related reasons, but also the economic differences in the between the two economies, China and Vietnam. However, it could be useful in the future for China to show to the European, when the political conditions will improve, likely, to show to the European institutions the progress made by China in the last years in the protection of certain types of fundamental rights. On the other side, I would like to address the interesting point raised by Dr. Yan Shawa. And I think that in this case, raising the point about the economic benefits, how economic benefits might have played a role in the ratification process. Well, they did. They did because Vietnam is not a small market. Now, Vietnam is a market of 100 million people. Secondly, the barriers to market, the market access barrier to enter Vietnam from a trade point of view, they're quite high. So especially on products of a specific interest for the European Union, I can mention agri-food products, I can mention cars and textiles and garment products. So the conclusion of the FTA will bring substantial benefits to the European Union. And the other side, also from the side of on the investment treaty, an increased protection of investment of Vietnam will have two different important impacts on the European investors. First, I would call a direct impact. I mean, European investors, they are incentivized to invest into Vietnam. First, because it's convenient. Secondly, because Vietnam is really a deep integrated country. You know, Vietnam, now the US, the US is not anymore a member of the Trans-Pacific Partnership, but Vietnam is the only country in the world that, when US was still there, having a free trade agreement with all the main partners: United States, European Union, Russia, Japan, Australia, New Zealand, India. And investing in Vietnam might have considered a sort of hub, investment hub to export in other countries, including ASEAN region. But on the other side, and these play an interesting role here, this would have been also an interesting incentives for European investors to relocate the investment they made in China in the past to Vietnam. Already there is a sort of relocation of investment for purely economic reasons. I mean that the cost of production in China increased substantially in the last few years, and already Vietnam benefited from that. But this agreement might have convinced several European investors having invested in China to relocate their investment in Vietnam. And this is interesting because this happened also on the negative side when China was hit by the tariff applied by the United States, a high tariff applied by the United States since 2018 on specific products exported from Vietnam. So several investors in China relocated their investment in Vietnam. So in conclusion, yes, the economic side may have played an important role in that. But again, I feel that the political side and the policy side is more important. And also is important in terms of, and I conclude here, in terms of the experience the European Union had with Vietnam in the last 15 years. You know, it has been concluded that having an agreement with the counterpart, even if the counterpart is not perfect, even if the counterpart lack of respect of specific human rights, it's better than keeping them out as an outsider, because the free trade agreement is not an agreement. It's not only an agreement, but it aims to create bilateral commission, aims to promote discussions, negotiations on different topics relevant for different chapters of the agreement. And this is the best way for the experience the European Union had with Vietnam in the last 15 years even to further raise the protection of specific rights in Vietnam as a third country. Okay, thank you.
Thank you, Claudio. Kolja.
Thank you very much. Thank you for the comments from the two discussants. First to Dr. Jan, I think indeed there is, of course, much more here on the table than human rights. I fully agree. But what we have to take into account, I think, is that this shadow of the future that I was talking about could have been overcome, could have been perhaps much more easily overcome if the situation in which we are in now wouldn't have escalated. And that is my point in the talk that I try in these 12 minutes that Mathieu gave us. The future, the shadow of the future could have been overcome. I think there was quite a lot of criticisms from the Greens within the European Parliament, but there were a lot of caucuses in the European, a lot of party groups in the European Parliament that saw and weighed actually the benefits of the investment agreement over the other issues related to labor rights, related to human rights. So, you know, when you look at EPP, when you look at Renew, even with S&D, I think the situation would have been actually quite favorable, I think, for actually, you know, perhaps with a couple of adjustments to actually sign. Now, with what has happened afterwards, and that is my whole point, the European Parliament has sanctioned, and then there was a retaliation of the sanction. So the question is, you know, what kind of strategy does the European Union have here? How can we best understand it? How can we best understand it? And my point was, it's basically two different tracks running in parallel. It's a trade policy on the one hand, and it's another policy on the other hand, that now comes together. Also because of the counter retaliation, and that makes it now so difficult. Let's not forget, MEPs have been targeted, and also parts of the European Parliament institutionally. The subcommittee has been targeted, and also the Political and Security Committee of the Council has been targeted. So this is what I call the shadow of the present, which I think makes it much more difficult. Justine Trudeau called it an attack on democracy. I haven't seen such a wording from within the European Union, but I've certainly seen that the MEPs have seen this as basically a sanction against the practice of its democratic right, as an intimidation of its right to actually give consent to the agreement. So that makes it difficult. And I agree with Professor Meng that the situation doesn't look good at all at this moment, due to the situation we are in. And I agree that dialogue is perhaps now what is needed. The question is, who is going to do the dialogue, and on which level can this dialogue be happening? And how political or non-political can this dialogue be? What will this dialogue be about? That was my point, basically saying, you know, there is of course much more to the CAI agreement, and I think everybody saw that. But the way how things have developed over the last 2 weeks makes it very difficult at this current stage.
Thank you very much, Kolja and Claudio, indeed, for your reactions to the comments by our two discussants. A few questions for, first of all, the two of you, and then more targeted questions. I mean, first of all, a question for the two of you, how to read the Chinese retaliations with respect to those who are not politicians. You could think of a number of academics, from Joe Smith-Finley to Adrian Zenz, or indeed, I mean, research centers such as Merrick's. And the question is indeed, why is there no sanction against EU businesses in China, which could have been the target of such sanctions? And would the answer to that be the fact that China took into account the risk of being challenged under existing BITs? So probably a question that the two of you could try to address. So I understand that this is indeed a very complex question. Then I have a question for Claudio. When was the EFTA translated into Vietnamese? Isn't it something that is done after the closer legal scrutiny over the agreement? And if indeed that is the case, then isn't it normal not to have the Chinese translation yet? So there was a question for you, Claudio, and then two questions directly targeted to Kolja. When you talk about the fact that the shadow of the future, Kolja, could have been overcome, the question is, could it be really overcome when you look at the kind of chronology of events in recent weeks, with the EU adopting its Magnitsky style, regulation early December, and indeed when such Magnitsky style regulation was adopted, it was probably to be taken for granted that indeed officials in China linked to those events happening in Xinjiang could indeed be the targets. So in that sense, if you look at the kind of chronology, adoption of the Magnitsky style regulation early December, conclusion in principle of the CAI end of December, could indeed this shadow of the future be overcome when you look at this kind of chronology? Then another question for you, Kolja, if I may. What are the broader lessons that we could draw from your presentation today in terms of the EU's future as a global actor? What we do see here again with the CAI is, the difficulty for the EU to reconcile its identity as a strategic actor, which tries to protect its economic interests, with this idea of the EU being a normative actor, which has, according to the EU treaties, as it was mentioned earlier today, to promote all those values which are included in Article 21. We got it from your presentation that principled pragmatism is probably not the answer here, but what are the kind of broader lessons which we can draw from the CAI? So if you could, if each of you could take 5 minutes to answer those questions, that would be excellent. So maybe Claudio, would it be fine to start with you again?
Thank you. I will be much shorter, and because the number of questions raised to Kolja, they are much substantial. I would move directly to the question about the VFTA translation. It was translated right after the first end of negotiation. So already in early 2016, the agreement was already there, available. So immediately available. And this is the issue. For the other issue, I would wait for Kolja first, because he has many more questions to answer. Kolja, I would give you the floor.
Thanks.
The floor and the hot potato, if I may say. Kolja.
Thank you. Perhaps I find a way to bring them back to you, to your camp, so you can help me. Now, with regards to the sanction and why businesses weren't targeted. Well, I said you can interpret the retaliation as a way to actually put the European Parliament to the test, right? We all have watched, Netflix, the Gambit, the chess series over the. This is chess in a way. From a realistic point of view, this is chess that governments play. So the question is, what do you try to do with that move? And I think one is, 11 for 11, tit for tat. Okay, that's the one thing. The second thing is, however, how can I make a move that puts my competitor, perhaps my rival, into a more difficult position in the next move? And I think this is what has been achieved. It can now be, it's in the camp of the European Parliament, very clearly. The European Parliament has, so to speak, now a very difficult situation to face. At the same time, we have very strong interests. We have Germany, we have German businesses, we have Italian businesses, we have French businesses. They're all waiting. They're all waiting. They all want to know. And of course, this puts the European Parliament, this puts the whole Union into another credibility test. It's basically undermining, you know, the legitimacy of the European Union. What is the European Union ultimately standing for? Is it standing for the interests of European business and citizens? Or is it standing for something else, for what Mathieu called a normative power approach? And I think this move, in that sense, is, in the best sense of the word, a smart sanction. You know, it has been a very targeted and very smart sanction, in the sense that it really can divide different interests within the European Union now. So I think that's why European businesses weren't attacked, because they are by and large in favor of this agreement. And perhaps one other issue then, with regards to the questions that Mathieu brought up, what is happening here to the EU as a global actor? Well, perhaps we can try to understand it also in the context of the second question which you have asked, Mathieu, which is basically how can we make sense of the possibility to actually give consent on this shadow of the future, given that the EU has acted the way it did over the last couple of weeks, basically making use of a new tool on sanctions. And I would say, well, first we have to understand what has actually happened here. I think it's very unclear what the timing was meant to be about. Why this timing? Why this timing? If you can of course you could read it as a timing that basically made life for the European Parliament very difficult, because you should have expected a retaliation of a sanction, right? When you sanction, it's very likely that you get a retaliation. So it would be very naive to think the opposite, I think. So the question is, so to speak, was it deliberately a move at this moment? I don't think so. I think it's another tale of uncoordinated, unstrategic EU foreign policy that is basically not seen as a whole, that is seen as a compartmentalized business. On the one hand, human rights policy, on the other hand, trade. And I think this is something that will be not that easy for the European Union to overcome unless it has to make very clear choices. And one choice would be to basically say we should have never entered this investment agreement from one point of view. From another point of view, you should have basically come to the conclusion we should have never sanctioned China because our strategic interests matter, our strategic interest to actually get this deal done. But to bring these two positions together is very difficult for the European Union. And I think that's the lesson from the last couple of days. The European Union finds itself again in a very difficult position to actually speak to the two identities, as you call it.
Thank you so much, Colli. I just would like to give the opportunity to Claudio to get the semi-hot potato back on his plate. So I don't know, Claudio, if you want to have the last word here.
Well, it's quite a complicated question. You know, I would respond, I would see it more as a political move than really a legal-based move. And I think that China is testing the water in this case. So to raise the level of confrontation with European, that is my suspect. And secondly, but this is connected also to your first question and what we discussed before with Professor Ying Menying. You know, I suspect that one of the reasons why the Vietnamese example cannot be used for the CAI is that not only, of course, China for the European Union has a different, importance than Vietnam. But on the other side, internally in China and Vietnam, the importance of the agreement is different. It seems that even for China, the agreement with the European Union is not as important as the agreement for Vietnam and the European Union. Just to tell you one thing, in the procedure that in Vietnam, they organize an event for the signature of the agreement with the representative of the European Union and Vietnam. And in practice here, the event was participated by all the relevant ministries of the government. Beside the Prime Minister, all the Minister of Trade, Minister of Planning and Investment, they're all there. There was the #2 of the Communist Party. There was the President of the Parliament and spokesperson. So meaning that, and this is connected also to your question. You asked me when it was translated. Not only it was translated right, the translation was available among ministries after the negotiations, but also during the negotiations, I know Vietnamese, they used to translate step by step part of the chapters. So they reported immediately to all the other ministries after negotiations in Vietnamese. Moreover, the European Union, after the end of the negotiation, which was 2015, and the ratification ended only 2020, already published in the EU website in January 2016, publicly, the agreement. And all the Vietnamese were aware of that. And the interest in the country was huge. So this is another point which might be relevant and confirming what Professor Jean Monnet said and addressing your point.
Thank you very much, Claudio. So it's now time to conclude this session. Let me once again thank our three speakers, Bin, Claudio, and Colia, for their excellent contributions. I think we really had a fantastic panel, to which also I would like to thank Professor Men and Dr. Jan also for their contribution to the discussion. So thank you very much to all of you for what was, I think, a really exciting panel. It's now time for me to give back the floor to Julien, who will take the lead for the conclusions of this event. But really, many thanks again to all the contributors to this second panel.
Thanks, Mathieu. I think we truly enjoyed this second webinar. Of course, as you could see, we could not cover all the aspects of the CAI today. But I remind you that we started on March 8th with the first webinar, and who knows, we might come back with a third webinar soon. Or to play safe once the political turbulences are over. Perhaps we could discuss also the cost of the non-CAI, so the political cost and the economic cost of not getting the CAI ratified in due course could be an interesting topic. And the legal consequences, because even if the CAI doesn't get ratified, I just want to remind everyone that the BITs remain in place. And the BITs may remain in place in a different political and economic scenario with different dynamics, which could be also very interesting to look into from the legal point of view. Quickly, I wanted to also draw your attention on the fact that Mathieu and I are working to put together a special issue for a top journal that we don't want to give the name now, but we will very, very soon get back to many of you by emails with more details. Our ambition is to try to wrap up this project in the coming 1 or 2 weeks. For the last words, look, I just want to thank you again, all the speakers, for these very interesting and stimulating contributions. It's been a very, very nice webinar. Thanks also for the participants that have been asking many questions in the chat box. And that's time to close and to say goodbye. Take care and keep in touch. Thank you.
Many thanks, everyone. Bye-bye.
Bye-bye.